Okay, am I live? I'm live. Hi guys. Hi guys. So it's not just me. There are actual internet outages this morning because I was going absolutely out of my mind trying to figure out what was going on. So that was great. And what else? What else? Of course, court started on time. So let's start, and then I'm going to tell you guys some crazy information.
Connor Grubb. Are there any further witnesses on behalf of the state of Ohio?
Your Honor, before they call witness, before the jury comes in, I did want to put, Ms. Stevens informed me that I needed to put a couple things on the record.
Okay.
Because the next witness, I believe, is Professor Stoughton, right? We would ask that renew our request that the court do an in-camera inspection of his grand jury testimony. We ruled on that, but I believe procedurally we're supposed to bring that up now, as well as renew our objection to the officer created or any type of testimony being allowed into that. We don't believe that would be appropriate.
Any response on behalf of the city?
Similar response as to our file response as to relating to grand jury testimony. We can see in our original response to that. There's not been any particularities being shown as it relates to the officer created jeopardy in the court ruled yesterday that it's not to be considered as a factor. The court is not going to instruct on that on jury instructions, so that it can't be considered to how the circumstances reasonableness of occupation. And I believe the testimony would be appropriate for that, and her testimony yesterday from Davis concerning his opinion as to what we should use it.
And note your objection. Anything else we need to put on the record prior to beginning the jury?
I don't believe so, Judge.
All right, go to the jury.
But you're going to say something that this was the witness or like take out of order?
I can.
That makes sense.
I can't believe we're starting on time.
Yeah, me neither, Judge. Most people use Stanley's to drink water. I use it for soda. What's up, nerd? How's it going? Thanks for being here. Internet problems and all. Hopefully it's nicer weather where you are.
All right, everyone gonna have to eat. Everyone have a good evening last night? Good, good. What we're doing, the next witness was taken out of order. He was unavailable to be here last week, and this would be the state's case in chief. Is there any further witnesses on behalf of the state of Ohio?
Thank you, Your Honor. The state call says so.
All right. I'm going to wait to share what I know until we get a few more viewers. It's freezing ass cold. Yeah, okay. It's pretty chilly here as well.
Little maze around here.
What did I just do? Oh, never mind.
Raise your right hand. Do you solemnly swear or affirm under penalty of perjury your testimony in this case to be the truth, the whole truth, nothing but the truth?
I do.
Have a seat. Pull yourself up close to the microphone.
Thank you. May I proceed, Your Honor?
You may.
Thank you. Good morning. Could you begin, please, just by stating your first and last name and spelling it for the record? Good morning. My name is Seth Stoughton, SETHSTOUGHTON. What is your current occupation? I'm a law professor at the University of South Carolina, Joseph F. Rice School of Law, and I'm the
Doesn't
faculty
even go
director there
here.
at the Excellence in Policing and Public Safety program. And how long have you been a law professor at the University of South Carolina? This is my 11th year there.
What courses do you primarily teach, or what are your main areas of research?
In the law school curriculum, I teach criminal law, which is a first-year required class. I teach criminal procedure. I teach police law and policy, and a seminar on the regulation of vice. I've also taught a class called Advanced Topics in Criminal Law, which I haven't taught in a while. It's been 8 years or so. With the Excellence in Policing and Public Safety program, or EPS, I teach principles of leadership and management, collaborative communications. I assist with evidence-based policing,
So glad you had
critical
to say
incident
it,
sentinel
or
event
you said it.
review,
I didn't have
sound agency management, collaborative communications, co-production of public safety. I feel like there's one more that I'm missing in there. Oh, civil rights for law enforcement leaders.
And do you teach exclusively in the law school? Do you do undergraduate?
Right.
I've taught an undergraduate class. I taught my regulation of vice seminar at our honors college, but no, my work with the law school is exclusively in the JD program and in the policing program.
And Professor Stone, going back to the beginning of your law enforcement experience, what did you do prior to becoming a law professor?
I served as a police officer with the Tallahassee Police Department, just under 5 years full-time, and stayed on as a reservist for another 6 months, a part-time officer. I was an investigator with the Florida Department of Education's Office of Inspector General, doing administrative and criminal investigations as it related to the Department of Education, sort of like the internal affairs unit of the Department of Education. And then I went to law school.
And what period of time were you a police officer in Tallahassee, Florida?
That was 2001 until the end of 2005, full-time, and then until May or June, I think, 2006, part-time.
And what type of area is that? Is it big, small, rural, metropolitan?
Tallahassee is Florida City. So it's the city itself is 90 square miles or so. We had 350 or so officers at the agency. The metro population was in the 200,000 to 300,000 range, something like that. I'm sorry, the city population was in that range. The metro area was a little bigger. Mostly suburban, I would say. Little bit of urban for what counts as North Florida urban, and then suburban, with a lot of rural outlying areas that were mostly outside of the city limits.
And what were your roles and responsibilities when you were a police officer in Tallahassee?
I was assigned to the Uniform Patrol Division. I was a Uniform Patrol Officer, which just meant I was in uniform, riding around on patrol, answering calls for service, self-initiating activity like traffic stops or business checks, just your normal beat cop. I had some additional duties beyond the assignment. I developed and taught self-defense classes in the community. I developed and taught some children's self-defense classes. I was a founding member of our special response team, and on that for about 2 years before I left.
And then when and where did you obtain your degrees?
My undergraduate degree was at Florida State, which I started before I became a cop and finished after I was an investigator. So it took me 10 years to get my 4-year degree. And then I went to the University of Virginia for law school and completed that one shockingly on time.
And Professor Stoughton, since you have been a law professor, have you published extensively in your field?
I have, yes.
And what are your primary focuses?
I'm a policing scholar. I study the regulation of policing, which essentially means I look at the legal and the extra legal rules, things like agency policy and culture that shape officer behavior. A lot of my work is focused on tactics and the use of force, but I've looked at a range of other things, everything from off-duty employment to the development of Fourth Amendment rules that affect policing, to the relationship between state law and agency policy and Fourth Amendment doctrines.
And what type of works have you published?
I've done academic articles both in law reviews, which is the type of publication in my field as a legal scholar, along with criminology articles. I work with a group of criminologists to do empirical work on a whole range of things. I've done book chapters on some of the same topics, and I have co-authored one book.
And is your work extensively cited and relied upon in the field?
Yes.
And do you present on the topics of your focus as well?
All the time. Yes. I present pretty broadly, both to practitioner audiences. So especially in the context of use of force review, the Washington, D.C. Metropolitan Police Department does something called their Police Leadership Academy. They bring in 70 or 80 officers from all over the country, and usually about half dozen or so international, for 3 weeks of training. They have me come up to do the use of force review piece. The most recent time is actually pursuits and use of force review. I've done the same thing with regional police leadership trainings with the Charleston Police Department. In a couple of weeks, I'm going to Nashville. There's a Tri-City Police Leadership Academy that's doing the same thing. So I also work specifically with agencies on request. That's one of the things that my program, the Excellence in Policing and Public Safety program, does, is work collaboratively with agencies in South Carolina to provide technical assistance on some of these issues. Beyond practitioner audiences, I present all the time to academic audiences. I was just last week at the American Society of Criminology conference. I present to judicial conferences. I've been here presenting on aspects of use of force reviewed at the Ohio Judicial Conference, for example, to attorneys at both prosecution conferences, defense conferences, combined conferences. So yeah, I present sometimes more than I want to.
And are you regularly involved in actual training of police officers on use of force and tactics?
Not usually with line officers, but often with investigators, supervisors, and command staff on reviewing incidents, yes.
And Professor Stoughton, do you get retained to provide an expert review of officer-involved use of force cases?
Yes, I do.
Roughly how many times do you think you have been retained to provide expert analysis?
At this point, it's hovering around 150 times.
And what type of individuals or entities will hire you for your services?
It's a mix. So it's across, in civil litigation, it may be a plaintiff's attorney or a defense attorney. Plaintiff's attorney being the one who is initiating the lawsuit, suing someone else, the defense attorney being the one who is defending that lawsuit from the plaintiff. In criminal litigation, I've been retained by prosecutors at preliminary review stage, at grand jury stage, at trial stage, as well as by criminal defense attorneys.
And have you offered opinions? Have you offered opinions both that an officer's actions were reasonable and unreasonable? Have you provided testimony as to both sides?
Yes.
And how many times roughly would you say you testified in court before?
In court is probably around 20 times testifying. In trial, 18, 20, 22, maybe something like that.
What courts have you testified in before?
Oh boy. Georgia State Court, Ohio State Court, Nevada State Court, federal courts in South Carolina, in boy, kind of a lot. I can look at my CV if you want the full list, but sort of all over the place. State court in Pennsylvania and New York, federal court in, I think, Virginia. Yeah, kind of all over.
And in the previous times that you've testified in court, have you been declared an expert?
Yes.
In what fields have you been declared an expert in?
Primarily in police tactics and use of force, or generally accepted practices relating to police tactics and use of force. In a couple of cases, it's been, Minnesota, I forgot about Minnesota. In a couple of cases, it's been police procedures more generally, sometimes investigative procedures or things like that.
Your Honor, at this time, the state would move to have Professor Stoughton declared as an expert in policing and use of force, generally accepted practices.
You can render.
Thank you, Your Honor. Professor Stoughton, were you retained to provide expert analysis in the shooting death of Takaya Young that occurred on August 24th, 2023?
Yes.
And what is your normal rate that you charge when you're retained to provide expert analysis?
It's changed a bit over the years, but in this case, if you don't mind, I will refer to my report to remind myself of what that is. It depends on when I was retained. In this case, it was $415 an hour. I'm sorry, 415.
And how many hours would you say roughly you've spent thus far working on this case?
Oh, that's a great question. 30, 35 hours, maybe?
And is that pretty standard?
Yes.
And Professor Stoughton,
That's literally the amount of time that we're hearing from all the expert witnesses, in case you are just now tuning in. One thing I do want to mention that's already kind of been reflected in the chat. Seth is known as a smooth talker. He's a bullshitter. He is a for someone who was a cop, he's very critical of police officers. Depending on the issue, that can be good or bad. Meaning, like, if there's corruption, of course, you want that called out. But he pretty much did the job for like less than 5 years, and was like, okay, I'm not going to be as much of a bitch as I'm coming off to be. Decided it wasn't for him and went to law school And this is what he does. This is what he does. He testifies, and I'd love to know which trial he testified in that was pro-cop, because all I've seen him do is anti-cop testimony. Just saying. Thanks.
So is your rate, is that kind of industry standard? Is that high, low?
I don't fully know. I know I charge more than some people. I know I charge less than some people. So I think I'm within sort of industry norms on that.
And what is it that you do when you are retained to provide expert analysis? Is it always kind of the same methodological approach?
It is. So usually the retention starts with a preliminary phone call. The phone call is laying out the sort of type of case that we're talking about. There are some aspects of policing where I can help guide an attorney towards an expert, but I am not the guy who's going to be helpful. Assuming that the case is something within my area of expertise, then the question turns to the sort of facts of the case. There are some occasions where I know, even from the preliminary conversation, that I'm unlikely to be helpful to the attorney in litigation. So if they want an informed opinion, I'd be happy to share that. But if they're looking for someone to help them make their argument, maybe I'm not the best person. If we get through that portion of the conversation, then there's usually a formal retention, and I'm provided the materials. Usually I get all of the materials in the case. Sometimes attorneys will curate the materials a little bit, so I'll get a subset of the materials in the case. And then the methodology is very consistent. I review the materials, I identify what the issues are. Once I identify what the issues in the case are, then I identify what generally accepted police practices were relating to those issues as of the time of that incident. And then I compare that standard to the officer's decisions or actions to determine whether the officer acted consistently or inconsistently with those generally accepted principles or practices in policing.
And Professor Stoughton, what is the difference between a generally accepted principle and a generally accepted practice?
So generally accepted just means it is broadly accepted in the field. Any reasonably well-trained officer anywhere in the country would say, yeah, that's more or less the way we do things. Policing is a little weird in that way because we don't have a centralized sort of top-down set of instructions. It's not like accounting where there's a book of generally accepted accounting principles. In policing, we identify what's generally accepted by seeing what bubbles up from the bottom to see what practices in the field actually look like. With the difference between principles and practices, principles are a little bit more abstract. They are concepts that inform policy or officer behavior, but they're not specific instructions. So a tactical principle, a generally accepted principle like tactics and using tactics to navigate the dangers of particular situations would be a generally accepted principle in policing. We want to manage officer safety and public safety in a way that balances safety against the police mission, right? Whatever the goal is in that particular interaction. When we're talking about generally accepted practices, that's much more granular. That's a little bit more specific. So in, for example, a high-risk traffic stop context, there is a protocol, a high-risk or felony stop protocol that officers will use that has been developed by policing over decades of practical experience. So it's literally a series of steps, and we would say that's the generally accepted practice in that particular context. Not everything in policing has generally accepted principles or practices, but there are certainly enough areas that do that we can say that is in fact generally accepted.
And as a policing expert, what do you do, or how do you go about determining whether or not a principle or practice is generally accepted in the field?
Yeah, this is where doing a lot of broad review is necessary. So looking at agency policies from all over the country, looking at training documents when they're available or information about police training, sometimes even things like national or representative surveys of officers to identify what's standard in policing, along with looking at the way that we communicate information to police practitioner audiences. So for example, there are police-specific publications, including non-academic, non-scientific publications like Police Magazine or Police One, that are used to get information to officers about police practices, or that are used to reflect common information between officers. There's also statements from groups like the Police Executive Research Forum or the International Association of Chiefs of Police that will develop model policies or consensus papers. And the important thing to note with any of those is something is not authoritative because the International Association of Chiefs of Police said it. It's not generally accepted because they said it. It's actually exactly the opposite. The reason that the International Association of Chiefs of Police is saying something is because it is generally accepted. That's how it gets into a consensus paper or a model policy.
And are you constantly staying abreast of developments in policing and law enforcement?
Yes, police tactics, police principles and practices change over time. Sometimes they change very abruptly, and we can identify a specific incident, a specific point in time. For example, if we look back into the mid-1990s, the police response to an active shooter situation was very, very different prior to the Columbine shooting than it was after the Columbine shooting. So sometimes there are, if you'll forgive the expression, triggering events that lead to a noticeable change in police tactics. But sometimes we just see a gradual shift as technology changes, for example. As body-worn cameras become more standard, we see slight changes in police practices.
And did you apply the general methodology you described in your role as an expert in this case?
I did, yes.
And what materials did you review in this case before rendering the opinion?
There were kind of a lot of materials in this case. I think I had something like 7 or 10 pages of materials. But the very short summary would be video, audio recordings, and written reports.
And did you review video in this case?
Yes.
And Professor Snowden, did you synchronize the different videos that were provided in this case?
Yes, it did.
And were you able to determine the timing of different events throughout the interaction?
Yes.
And were you able to synchronize the different videos so you could provide screenshots of different videos happening simultaneously?
Yes. So I load the videos into an editing program called VSDC that allows, first it allows you to import the video in their native format, their native frame rate. So if a video comes in at 30 frames per second or 29.97 or 32 or whatever it is, it will load that into its native frame rate. You can load multiple videos into it, and then you can display the videos side by side with run timers. So you can see either how many frames have been going since that video started, or the elapsed time from the start of that particular video.
And did you synchronize Officer Grubb's body-worn camera, Sergeant Moynihan's body-worn camera, as well as the Kroger surveillance video?
Yes, I did.
And how are you able to line up the times in the different videos?
So there are two different sort of things to check when you're trying to line up these videos, right? One of which is you look for audio events, like things you hear on the video recording. If you know, like an audio waveform, the little stereo symbol, you can use that visually to help identify, particularly when there are peaks in it. You can identify when those peaks overlap between two videos, and then it's a matter of lining up that audio waveform. You also listen to the video as you watch it. And when you have videos where the audio is out of sync, it's very distinctive because you're hearing the same thing ever so slightly off of each other. So when I synchronize videos, I don't turn either of the videos' audio off. I leave all of the audio on, and then listen for a complete overlap where it sounds like a single audio source instead of two different audio sources. Now that's when I have audio, and one of the videos in this case, the security camera video, didn't have audio. So without audio, or even in the videos with audio, you're also looking at visual events. You're looking at identifiable events that happen between videos, which might be a door opening or someone's arm moving up and then down, where you can identify in the video the frame at which the hand hits its apex before going down, and you can line those up between videos.
Were the embedded timestamps in the different videos consistent with one another?
No, not at all. And that's actually very common. The embedded timestamps, even in two videos, like two body-worn camera videos with the same manufacturer, the embedded timestamps will be fractions of a second or even entire seconds off. In this one, I'd have to go back and look, but the timestamp between the security camera video and the body-worn camera video was substantially misaligned. So you'll see different times in the embedded timestamp at the same time that the same events are happening.
And will you always synchronize video when you're retained as an expert to assist you in your analysis?
Not always. Sometimes synchronized video is provided for me. Sometimes there's only one video, there is nothing to synchronize, or there is no overlap in videos, so there is nothing to synchronize. But it's pretty common. I would say I do it in the majority of the cases where there's multiple videos. And
did you provide freeze frames in your report of the different videos at the same time?
I did, yes.
And were those put into a PowerPoint?
I did not put them into PowerPoint, but yes, they were.
Your Honor, may I publish this as demonstrative evidence to assist with the testimony?
That's fair.
Professor Snowden, what are we looking at this screenshot you provided here? Is this kind of a setting of the scene?
It is. So I will break down the different little pieces of it. So in the bold, what you see is the source of that video. This is Kroger parking lot security video. Then you see the timestamp that is on the video itself, which is 18:27:48. The number in the parentheses is the runtime of this video. That is, at this particular frame, this particular video has been playing for 13 minutes, 47 seconds, and 0.700 seconds. Cropped and marked underneath that, that indicates what I did to this image. So I cropped it, which is why you don't actually see the embedded timestamp. That is, I've zoomed in a little bit on it, and marked because I have labels that obviously do not actually appear in the original video. So the labels with their little arrows point to different things of note. And yes, this is relatively early on, sort of setting the stage for the reader of the report.
And is this shortly before the use of force incident?
It is, yes.
And what are we looking at in these frames?
So this is the point at which Officer Grubb has moved in front of the vehicle, as visible both from his body-worn camera on top. Again, you can see the title of the video, the runtime, the parentheses, excuse me, the embedded timestamp, the parentheses is the runtime. And then both of these videos are cropped. This is the Officer Grubb's body-worn camera on top and the Kroger security video on bottom.
And have we moved slightly forward in time here?
We have, yes. So if we, the easiest way to sort of track the time, for me at least, is to look at the runtime, the number in the parentheses. So here, Officer Grubb's body-worn camera on top, that is not cropped. That's the full picture of his body-worn camera. And then on bottom is the Kroger parking lot security video at the same point. That one is cropped, and obviously you will note that the quality is not perfect.
And what has happened thus far at this point in the screenshot?
So at this point, Ms. Young has turned the steering wheel to the right. Officer Grubb has drawn his firearm, and you actually see it there in his right hand in his body-worn camera at the very top right of that picture. You can see his arm out with the firearm pointed.
And had the vehicle moved at all yet?
I don't believe it had moved at this point. I can look at my report to make sure, but I don't think it had edged forward initially. If you'll give me just a second, I'd like to confirm that. Sorry, it's a long report. Give me just a second. No, I don't believe so. Wait, sorry, I'm just checking. Yes, I'm sorry. I believe her vehicle had edged forward at that point, at the point where he puts his hand on the front.
Does the putting of the hand on the front of the hood happen right after the vehicle first moves forward?
I think it happens after the vehicle moved forward for the second time. So the vehicle sort of moves forward a little bit, stops for a second, and then moves forward again. And the hand goes on the vehicle, as I recall, after the vehicle starts moving the second time.
And what are we looking at in these videos?
So this is a lot. The page is very busy, and I apologize for that. But this is synchronized videos where they are synchronized in horizontal order. So on that top row there, all of those videos are depicting things that happen at the same time. And that's true as you go down every row. So although the embedded timestamps and the run times are obviously different because the videos have different embedded timestamps and they start at different places, what you're seeing is screenshots of the synchronized video. This is not every frame of the videos. This is instead every 0.2 seconds, every fifth of a second. There's a jump to sort of the next row. So there are some frames in between these.
And what is happening right now during these synchronized screenshots?
So you can see in the leftmost column, which is the Kroger parking lot security camera video, you can see Miss Young's vehicle moving forward and to the right. In the middle column, that's Officer Grubb's body-worn camera. You can see the perspective from his body-worn camera. And on the right is Sergeant Moynihan's body-worn camera. So you can see the perspective of that camera depicting the same incident at the same time, but from different perspectives.
And are these rows moving forward in time?
Yes, every row moves forward 0.2 seconds. So if you look at the embedded timestamp, It's not super helpful because I'm breaking things into smaller than 1 second increments.
Why
But
are
if you look at the runtime, that number in the parentheses, you'll see, for example, the Kroger parking lot security video goes from 1414.533 to 1414.733, 0.933. That's just that jump forward in 0.2 second increments.
And does this series of screenshots lead up to the moment that deadly force was used?
It does, yes. This is a continuation. All we are doing is advancing time in that 0.2 second, that 0.2 second increment. So you can see again the vehicle continuing to move to the right. Officer Grubb sort of moving to the right, his hand remaining on the vehicle there. And from Sergeant Moynihan's, you start to see aspects of where, like in the third column, second row, you can see a little bit of where Officer Grubb was.
That's the one we were previously on, was it?
Yes. So there were 3 pages of that 0.2 second progression, right? I think we skipped through either the second or the third one of those, but that's what they show.
That'd be the first.
That's the first one, and then the second one, and then there's one. So that's the one that we were just looking at, where you can see Officer Grubb in column 3, row 2, and then there should be one more.
And is that where you can see Officer Grubb? Is that Sergeant Moynihan's body cam?
Yes, Sergeant Moynihan's body cam, the center most row there, you can see Officer Grubb.
And then the Officer Grubb video in the centermost row, is that the exact same time as you see Officer Grubb on Moynihan's body cam?
Yes. And this is the third of the 3 pages. Again, it's continuing to show the same thing, just different events because time is progressing. So here you can see this Young's vehicle continuing to move forward. Officer Grubb now sort of moving over to the left of the vehicle, both on the Kroger security camera video, on his video, and you can see it on Sergeant Moynihan's video.
And is this still before deadly force had been used?
It is, yes.
And what do these screenshots?
So these are the 2 frames. This is now not separated by 0.2 seconds. It is instead separated by 0.033 seconds, which is 1 frame of these 2 videos. And it's the difference in frame, the frame immediately before the shot and the frame immediately after the shot. That is, there is no frame of the video between these 2 things, right? It is literally 1 frame to the next. In the top frame, we do not have the bullet hole in the window. In the bottom frame, we do.
So here can we see that the shot occurred between this 366 thousandths of a second and 4 thousandths of a second?
Yes.
And what is the timing of when the gun was discharged? How do you have that indicated?
I'm sorry, I'm not sure I understand your question.
Do you use, well, I guess you could use run length of the actual video, run length of the synchronized video.
Oh, yeah. So you can, I mean, if what you're asking is just how do we identify when that shot was fired, we can identify it on that body-worn camera video, right? The runtime of 5 seconds, 5 minutes, 33 seconds and 0.4 of a second. We can also use the runtime for the approximately synchronized video, which has a different runtime because that entire approximately synchronized video starts at a different spot than this particular video.
So is the 5 minutes, 33.4 seconds, is that the runtime of Officer Grubb's body-worn camera?
It is, yes.
And is that the time you can pinpoint that the shot was actually fired?
I think the better way to put that would be, we know that by that point the shot had been fired, right? I have about a 30th of a second there where I don't know exactly where in that time the shot was fired, but I can tell you it hadn't hit the glass on the top frame and it had hit the glass by the bottom frame.
Were these screenshots of where the car finally came to rest after force was used?
Yes, that's correct.
And Professor Stoughton, what are we looking at here? Is the in relation to the moment that deadly force was used?
Sure. So this is now, instead of presenting all 3 videos separately, this is consolidating the 3 videos into my what I refer to as the approximately synchronized video. Approximately because I still have a 30th of a second of play just on the nature of when those videos start and stop. So this is as close as I can synchronize these videos. And what you see, if you look at Officer Grubb's body-worn camera, the runtime there, the top one is 5:33, 5 minutes, 33 seconds, and then 0.333 seconds. That's slightly before the 0.366 that we saw earlier. It is 1 frame before that. The bottom one is the 5 minutes, 33 seconds, 0.4, And you can actually see in the corner there, the bullet hole. That is the first frame of that video in which the bullet hole appears on the screen. So this tells you what was happening on all 3 cameras, looking at them simultaneously, 2 frames before, and then the first frame at which the bullet appears, the bullet hole, excuse me.
So is Moynihan's body cam at the bottom? Does that show Officer Grubb at the moment the bullet hole appeared in the windshield?
Yeah, so in the bottom compilation of videos, that is approximately synchronized video, 14 minutes, 16 seconds, and 1/10 of a second, 0.100, that shows all 3 videos at the same time. So you can see the bullet hole on Officer Grubb's, which is the top right image, and you can see a little bit, at least, of Officer Grubb's positioning in Sergeant Moynihan's video, which is the top left image, along with the not cropped, so it's zoomed out version of the Kroger video at the bottom of those 3.
And then here, is this actually immediately after the gun was discharged?
Yes, so this is 0.266 seconds after that bullet hole appears in the windshield. And maybe the easiest way to track that is, again, looking at Grubb's body-worn camera video. In the runtime, we saw the bullet hole appear at 5:33.4. This is 5:33.666. So that's 2.266 seconds, just over a quarter of a second.
And where can you see Officer Grubb on Sergeant Moynihan's body camera?
Sergeant Moynihan's body-worn camera is the top left image there. You can see Officer Grubb sort of to the side near what I would describe as the front quarter panel of that vehicle, the driver's side front quarter panel.
And how long was this after the bullet hole appeared in the windshield?
It was 0.266 seconds, just over a quarter of a second later.
Professor Stoughton, after you reviewed all of the materials in this case, based on your training, education, and experience, were you able to render any opinions?
I was, yes.
And what were the opinions that you rendered in your report?
As you see them displayed on the screen there, I had 2 opinions, one of which related to Officer Grubb's decision to move in front of and take a position in front of Ms. Young's vehicle. That was tactically unsound. It was unreasonable. It is unjustified risk-taking under the circumstances. And it's a position that is foreseeably likely to contribute to a officer-involved shooting. The second one relates to the decision to...
Why? Why would that be? Because you knew that she was going to try to plow him down? Just curious.
Remain in front of the vehicle and to use deadly force rather than to get out of the way of the vehicle when that's an option. That's what we expect officers to do. So that decision to draw his firearm and then use deadly force as opposed to moving out from in front of the vehicle where he had put himself is also just professionally inappropriate and not consistent with generally accepted practices.
Now, Professor Stoughton, to break down the first opinion first,
Sure.
Could you describe and
My
define what
opinions.
tactics are in the world of policing?
Sure. Tactics, in a nutshell, are how officers manage the risks of a situation and how we balance priorities. So one priority is for the officers to do whatever it is that they're trying to do. That might be investigate someone or serve a search warrant or apprehend someone, whatever the sort of police mission is in that particular context. But there are also risks and dangers and the potential for threat in any type of police action. So we use tactics to try and advance the police mission in the way that is safest for the officer, for the public, for the suspect themselves. Tactics are how we engage in that balancing. That's kind of abstract and academic. So the practical way is tactics are how officers keep themselves and the public safe while doing the job that we want them to be doing.
And are the reasonable tactics to use, and is it always context dependent?
Yes, yes, absolutely. There are entirely different tactics that we expect of officers, for example, in an armed barricaded subject situation, as opposed to an active shooter situation. It would be wildly inappropriate to use reverse tactics, right? With an armed barricaded subject, you set up a perimeter, you take lots of time, you have negotiators, you set up lines of communication. You don't do any of that with an active shooter situation, right? So the tactics are very much geared towards the facts of the particular situation.
And when you are asked to provide an expert analysis on whether or not an officer's actions were reasonable, do you offer your opinions on what the best tactic should have been or what the reasonable actions should have been or were?
Yeah, no. My opinion is based on what the generally accepted practices were at the time. That is what's reasonable at the time, keeping in mind that reasonable is not best. It is unrealistic to expect officers to make the best possible decision, especially in a high-stress, time-pressured environment. But they still have to be professionally appropriate and make reasonable decisions and take reasonable actions in those situations. So we don't expect in this context, right, when I'm assessing a case as an expert, I'm not looking for best possible outcomes. I'm not applying best practices. I'm looking at what the field has generated as generally accepted in that particular context.
Is there, in any given situation, is there typically a range of reasonable responses?
Yes, very often there's an entire range.
doesn't
It
seem
could be
level.
that X was reasonable, Y was reasonable, and Z was reasonable. The right way to think about reasonableness, I think, especially in the police tactical context, is not as it's not as a coin, right? Where on one side you have heads and that's reasonable, on the other side you have tails and that's unreasonable. But instead think of it much more as a spectrum. There's a range of reasonable options, some of which might even be more reasonable or less reasonable, but there's a range of reasonable options. At some point on that spectrum, however, there is a line that says there's also a range of unreasonable options. So to a significant extent, what I'm trying to do is figure out, based on what generally accepted practices were at the time of the incident, where on that spectrum an officer's decisions and actions should be plotted.
And how, in the world of policing, how do you go about assessing someone's tactical decision making?
So I can give you the complicated version or the simple version. The complicated version is you actually do something of a decision tree, right? You look at the different points at which an officer acted or made a decision, and you ask whether, under the context of this situation, that decision was appropriate or inappropriate, whether it was reasonable or unreasonable, whether it was consistent or inconsistent with generally accepted practices. The way that you actually answer each one of those questions at the different points in the decision tree for tactics is basically weighing the tactical benefits against the tactical costs. It's kind of risk-benefit analysis or cost-benefit analysis. What are we going to get out of this, and what kind of danger might it create? That's important because we expect officers in many circumstances to put themselves in harm's way, and it's professionally reasonable and appropriate to do so. The active shooter situation that I mentioned is sort of the best possible example of that. It is very dangerous for officers to rush in somewhere when they're dealing with an active shooter, but we expect them to do that because we view the danger created by the officer's actions as worth the potential risks. Saving the innocence from the active shooter are worth that danger. In other situations, it doesn't make sense for an officer to take risks when they aren't justified by the situation. So one example that I use in training is if an officer is trying to apprehend a jaywalker and he sees someone jaywalking and then the light changes, and the only way that the officer could go and apprehend that jaywalker is to throw himself into traffic on a busy road with cars traveling at high speed. And if he doesn't do that, the jaywalker is going to get away. Well, in that case, it's still not worth the risk of doing that. Stepping into traffic is very high risk, and the reward of apprehending a jaywalker is pretty modest, right? So in a situation like that, we would say the risk vastly outweighs the potential benefits.
What a douchebag.
And is it generally accepted in policing that situations are often dynamic, so a tactical decision making can change as that same situation continues to develop?
Yes, absolutely. Officers' decisions have to evolve as a situation evolves. There are situations where it may have been tactically appropriate to take one position, but it's not tactically appropriate to stay in that position, for example, right? The fancy police terminology is often tactical repositioning there. You were fine here, now you're not fine here, so you move to another area that provides some tactical advantage. Yeah, officers have to change and adapt as the situation changes.
And is it also, in assessing an officer's tactical decision making, is it generally accepted in the realm of policing to avoid hindsight bias? As
you're reviewing an officer's incident, yes, you want to avoid hindsight bias. Hindsight bias is this really pernicious little human cognitive bias that it affects the way we view things based on the outcome of those things.
Just want to say that using words like pernicious really aren't going to, in my opinion, go over well with the average layperson. I just felt like saying that. Thanks.
And that was wildly academic, so let me try and break that one down just a little bit. When we're analyzing an officer's actions, when we look at that point in the decision tree, we ask, was that an appropriate or reasonable decision based on the information that we knew at the time, based on the information reasonably available to the officer at the time? We don't ask whether it was a good decision based on the outcome of that decision, because sometimes a good decision can still have a bad outcome. That doesn't make it a bad decision. It was a good decision at the time, even if it led to a bad outcome. The same thing is also true in reverse. Just because there's a bad decision does not mean that it's a good outcome and therefore everything is okay, right? A bad decision is still problematic and potentially worth addressing, even if the outcome worked out just fine. So hindsight bias is the potential for the outcome and our knowledge of the outcome to affect the way that we evaluate the decision at the time. And we have to address it by being very deliberate about looking only at the information at the time and separating it from the ultimate outcome.
So does avoiding hindsight bias mean that officers' decisions can't be reviewed and assessed at all?
No, absolutely not. To avoid hindsight and what the Supreme Court has referred to as the 20/20 vision of hindsight, all that means is we don't use information developed after the fact to assess an officer's decision-making, because the officer couldn't have been aware of that information at the time. That is, that information couldn't have affected their decision-making because they didn't have that information. So that's what we mean by avoiding hindsight in use of force.
And Professor Stoughton, when it comes down to policing tactics, how does the element of time factor into it?
Time is the most important tactical concept. Time is what officers need to make better observations, to go through a better decision-making process, to get the additional resources that they may need to deal with a particular situation, even to move from one position to another, right? That takes time. So a large focus in police tactics is in creating time, giving officers more time to address a particular situation. A use of force incident can happen very, very quickly. The phrase that's often used is split second, right? It can happen in a split second. Tactics, to a very significant degree, are designed to avoid putting officers into a position where they have to make an actually split-second decision. The goal is to give officers as much time as the situation allows so that they can make the best possible decision and a professionally reasonable and appropriate decision in that context.
And then in that same regard, what is tactical restraint?
Tactical restraint is the idea that sometimes moving forward is not the best tactical approach, that it can create some dangers that are not justified in the situation. So if officers could go into one position that is dangerous or they could stay in a position where they have some relative safety, they have some tactical advantage, tactical restraint would say, well, unless that moving forward and taking the dangerous position is specifically justified, unless there's some compelling reason to do that, you should actually exercise restraint, wait the few more seconds or minutes or whatever it is to maintain that tactical advantage, which might be improving officer safety or public safety or the safety of the subject.
And Professor Stoughton, can you just describe for the jury, what is the concept of officer-created jeopardy?
Sure. Officer-created jeopardy is just a phrase that refers to unjustified risk-taking. It's not a magic phrase. It doesn't have any independent meaning. It's a term of art that was developed by the Savannah Police Department in the early 1990s that refers to officers putting themselves into positions where the dangers outweigh the benefits, right? It is a risk-taking behavior that is not justified under the circumstances.
Yeah, because he would love to have ended up as a quadriplegic for his wife, who is, never mind, and his 2 kids. Like, that would be in his best interest, right? Yeah. This is ridiculous.
Circumstances.
And if someone were to state that that is purely an academic concept and isn't present in peace officer training curriculums, what would your response to that be?
I think that's wildly ill-informed. Tactics made their way into police training when we started formalizing police training in the 1920s. The very earliest records of formalized police training have a discussion of tactics, and tactics are about making professionally appropriate risk balancing decisions, right? About not taking unjustified risk. So we see in the annals of criminology from 1929, a discussion of police tactical training. We see an explosion in police tactical training starting in the 1960s and then really getting into the 1970s with practical work by, among others, NYPD Lieutenant Jim Fife, who developed a whole set of tactical principles in his work at the NYPD to help address an increase in officer-involved shootings. In fact, Jim wrote an essay on the split-second decision-making that he called split-second fallacy, pointing out tactics are what save us from making split-second decisions, right? So we use good tactics to avoid putting ourselves into time-pressured situations where we can't figure out how to respond, so we may have to escalate in a way that if we took a more restrained, a more tactically sound approach, we wouldn't have to at all. Tactics are part of the training of every police academy in the country, including here in Ohio in the basic officer certification program. There's an emphasis on tactics and approach. You don't always see or hear the phrase officer-created jeopardy, but that's because the vocabulary is not universal. The concept is certainly universal. In the same way that when we're talking about when officers walk up to a car, a lot of places call that an approach, and some of the Ohio training material refers to it as a walk-up. It's not the vocabulary that's important, it's the concept that that vocabulary is trying to express.
And did you review some Ohio police officer training curriculum materials in the course of this case?
I did, yes. My understanding is they were the materials in play at the time of Officer Grubb's basic recruit training.
And did you observe tactics in there consistent with generally accepted principles and practices?
Yes.
So if not the term officer-created jeopardy, are you saying that concepts related to officer-created jeopardy are prevalent throughout peace officer training curriculums?
Yes, absolutely. The idea that officers should use good tactics and that using bad tactics can put officers into unnecessarily dangerous situations, which is why we use good tactics, is ubiquitous in policing.
And what is the generally accepted position in policing on officers placing themselves in front of a vehicle's path of travel?
Don't.
No.
It's very
no,
straightforward.
No.
Vehicles can run you over. They can hit you. They can.
That is absolutely incorrect. Go to the Blendon Township use of force, use of lethal force. Go to the handbook. Like, there are situations in which this is an appropriate reaction. Hindsight, right? This is exactly what he's doing. Oh my Lord, please give me strength.
Drag you, and that's a capital B bad thing. So the way to remove that as a possibility is to not move into, and certainly not to remain in, a vehicle's path of travel. Don't be in front of the vehicle, don't be behind the vehicle. Vehicle can't really hurt you if you're standing next to it, so do that.
Is this a topic that has been considered extensively in the realm of policing?
Yes, absolutely. It pops up in training presentations by the Police Executive Research Forum. Going back at least to the late 90s, there's a discussion of officers not standing in front of vehicles. There are articles in police media from 2005, 2006, all through the 2010s about not taking or maintaining a position in a vehicle's path of travel. The basic rationale for all of that is standing in a vehicle's path of travel will typically offer very little in the way of tactical advantage. It might offer some, depending on the situation, but it's typically not going to be much different than the tactical advantages offered by standing next to a car. But it exposes the officer to a substantial amount of tactical risk. Again, vehicles can hit you or drag you or run you over if you're standing in front of them or behind them. So when the risk outweighs the tactical benefits, as a general matter, police tactics would say, don't do that.
Are there any tactical benefits to an officer placing himself in a vehicle's path of travel?
There can be, depending on the situation, but it's often pretty modest. There can be some visual benefit. Maybe the officer gets a perspective that they can look into a vehicle that they might, in a way that they might not otherwise be able to. That does have some tactical benefits to it. However, if the officer can look into other windows, whether those windows are open or there are other officers looking in, or the windows are not darkly tinted or mirror tinted or something like that, we can't ignore the fact that we might get the same tactical benefits from a different position, right? It may not be the only way to get that tactical benefit. One of the tactical benefits, I suppose, is communicating to the person in the car, hey, you're not free to leave right now because here I am standing in front of you like a human traffic cone. Again, that might have some tactical benefit, but it's not really distinct from the tactical benefit of telling someone the same information while not standing in front of the car. Minimal tactical benefit, maybe no increase in tactical benefit, and again, exposing officers to a substantial amount of risk. Depending on the situation, there may be some other tactical benefits, but usually they're relatively modest. And there is always a substantial risk of the car moving unless the car is inoperable, right? If the car is inoperable, then it doesn't have a path of travel, so we get the same tactical benefits without those tactical risks.
And how is an officer standing in front of a vehicle, how does that relate to the concept of officer-created jeopardy?
Sure. So again, officer created jeopardy just referring to unjustified risk taking, or the idea that the position of an officer has to balance the risks of that position or action against the benefits of that position or action. If an officer steps in front of a vehicle when the tactical risks substantially outweigh the tactical benefits, we'd say that is not justified risk taking. And the term of art that we might use there is that's an example of officer created jeopardy. In fact, in the book that I wrote, which is Evaluating Police Use of Force, my co-authors and I use this example exactly as the paradigmatic example of officer created jeopardy. There was an officer, Kimberly Rasso, who was working off duty at a mall and investigating a shoplifting incident and stepped in front of a car and ended up shooting the driver when the car moved towards her. And the point is exactly the tactical benefits are pretty limited. Not that there's no goal in stopping that car and apprehending that shoplifter. Of course there is, but the tactical benefits are substantially outweighed by the risk presented to the officer, especially when it's foreseeable that if the car moves forward and the officer says, oh, I'm in danger, and uses deadly force, now we've just shot someone in a shoplifting investigation.
And Professor Snowden, what is considered a better position or the generally accepted practice when it comes to approaching people?
So there are a ton. And again, this is where there are a whole range of reasonable options rather than a specific reasonable option. If officers are trying to maintain visual contact, that is, they're trying to look into the car, and we have two officers, right, where one of them, in this case, Sergeant Moynihan, is standing on the driver's side of the car. It's possible, but maybe not highly beneficial for the two officers to just stand next to each other, right? More tactically beneficial would be a sort of standard traffic stop approach where you have an officer standing on either side of the car. Officers certainly want to avoid the potential for a crossfire situation, but there are a number of ways to do that, including standing in front of what's called the A-pillar, which is that line of metal between the windshield and the driver's window, or the windshield and the passenger window, right? If both officers are standing slightly in front of that A-pillar, they still have visual contact from both sides, and also are not in a position where, in the event of gunfire, they will be aiming at each other. Same idea, you can have officers standing behind the B-pillar. The B-pillar is the line between the driver's window, the driver's window and the driver's side rear passenger window, or the front passenger window and the back passenger window, right? If officers are stepping back a little bit, they can look into the car, keep the visual, and also not put themselves into a crossfire situation. Or some combination where you have officers not like this, but in sort of a V shape, if that makes sense.
And we talked about the general position of policing on an officer situating himself in front of the vehicle path of travel. What about the defendant's decision to situate himself in front of the vehicle in this particular case?
It's a really bad idea. The tactical benefits are marginal or modest at best, and the tactical risks are substantial.
And Professor Stoughton, if someone were to claim that standing in front of the vehicle was the best tactical position in order to potentially avoid crossfire, what would you say to that?
Not when you have motorists sort of immediately behind the vehicle in the line between the position in front of the vehicle, the driver of the vehicle, and what's known as policing as the backdrop or the backstop. That is the thing behind your potential target.
And do you have the...
Just so you guys know, the reason I've been quiet, I was looking online at this case that was mentioned in his book. I literally clicked every single tab except the one I needed. Okay. Vanessa Abraham, filed suit against Officer Kimberly Rasso in the township of Cherry Hill in the United States District Court of New Jersey, The complainant argued violations of 4th and 14th Amendments, along with various state law claims against Rasso and other mall-related defendants. Rasso, I feel bad if I'm pronouncing that correctly. Rasso filed cross claims against several parties, and the actions were consolidated. The defendants moved for summary judgment. The district court granted summary judgment in favor of Rasso, holding that her use of force was objectively reasonable as a matter of law. So I don't know why he would mention a case where a police officer was literally did the same thing, essentially. And that person, it was shown that they did the right thing. What in the hell?
The person marked here in this screenshot?
Yes. So over on the bottom left, you can see the person with the little tag, the mark as motorist. That's a motorist associated with the car that the officers had been helping with just a few minutes ago. You can also see in the sort of yellow top there, I believe that's the Kroger employee. Additional, if minor point, auto glass does some really weird things to bullet trajectories, so we don't always know where the bullet is going to go after it strikes, well, anything, but especially not the glass or metal from a car.
And does a tactically sound position approaching a vehicle eliminate the possibility that the vehicle could even be perceived as a threat?
Yes. If you remain to the side of the vehicle cannot run you over. It lacks what we refer to as the opportunity to be used as a weapon against the officers.
And is the goal of tactics to conclude a situation in the safest possible way?
Yes, to try and achieve the police goal in a way that appropriately balances public safety, officer safety, and the safety of the subject with whom officers are interacting. To do so in what is hopefully the safest and least intrusive way.
And what is the what is the generally accepted position in policing about how far officers should go in order to investigate a crime or apprehend a subject?
So it very much depends on the situation. I know I'm going to sound a little bit like a broken record, but the ultimate question is, are the costs worth the benefits, right? Especially keeping in mind that when officers are doing some kind of field investigation, there are different risks.
No license plates. Had her car backed into a handicap spot without a placard for easy getaway. She was on a theft diversion program for previously stealing at other places. She had a warrant out for her arrest. Am I missing anything? Just open that up to the class. There was no way. Okay, let's just. They had reasonable cause and they absolutely intended to pursue charges. It's not like they could be like, okay, you're free to go since you don't want to cooperate. Cool with us. Peace. We'll just catch up with you later. The location of that Kroger, there was no way they would find her. That leads to a major highway, which leads to 3 other highways. I just had to say that. Sorry.
Risks that officers may be worried about. One of the risks is being run over by a car. Another of the risks is the person that officers are investigating getting away. If we look at that, the risk of getting away, we want to stop that, right? If someone is going to be investigated or arrested for an incident, whatever criminal incident that is, that's certainly a police priority. But just like every other police priority, it's not a priority that we expect or want officers to pursue at all costs. They have to do so in a professionally appropriate way. And just because in a situation like this, just because a motorist does leave, does not end an investigation. It's really a false choice to say officers either have to put themselves in life-threatening danger or they lose any ability to investigate this incident at all. Most shoplifting incidents are investigations that officers conduct after the suspected shoplifter leaves. So you use security camera footage or witness testimony.
They wouldn't have been able to get a
identify
hold of
who
her.
your offender is, and you go and get a warrant in a normal investigative process. Like the jaywalker, the choice of like, do I just let him get away or do I create extreme danger to myself? There's kind of only one professionally appropriate answer to that question. But unlike that jaywalker hypothetical, it doesn't end with just letting them get away, right? It's not a police endorsement of the underlying activity to do an investigation that will result in a later apprehension. So we should specify that the risk of getting away isn't the risk of getting away scot-free and never getting caught. It's just the risk typically of delayed apprehension after investigation.
And does policing in developing generally accepted practices and principles, does it incorporate cases from the United States Supreme Court?
Yes, policing. So the standard that I'm applying is this generally accepted principles or practices in policing. Policing as an industry is certainly responsive to law. That is, principles from some of the seminal use of force cases by the Supreme Court have been incorporated into those generally accepted practices.
And has the Supreme Court spoken to this concept of weighing the balances against when to continue trying to investigate or apprehend someone?
It has. So in a 1985 case called Tennessee v. Garner, the officer in that case was investigating a reported home burglary, saw the burglary suspect fleeing from the house and starting to climb a fence, and knew at the time, if this guy jumps the fence, I'm not going to catch him. He is going to get away. And potentially, especially maybe given the state of investigative techniques and technology at the time, if he gets away, he's going to really get away, right? There's unlikely to be a later apprehension. In that case, the officer shot and killed Edward Garner, and the Supreme Court said that that was unconstitutional. And their line in balancing that you're asking about is, it is not better that all felons die than that they escape. That is, sometimes in balance, to avoid killing someone, we just don't solve the crime at all. Now, again, that's a very different situation here, where we have at least a witness standing by to provide information and video.
And my next question was going to be, in this case, had Ms. Young left, were there other investigative avenues that still could have been pursued?
Yes, absolutely. It does not mean for sure that they would have identified her and been able to apprehend her later. But yes, there was a professionally reasonable likelihood of being able to do exactly that.
Oh,
And does this particular case illustrate why policing has the generally accepted position on standing in front of the vehicle that it does?
I believe it's actually an excellent example of why that principle exists, right? Why we have the practical guidance to not stand in front of vehicles, to reflect some of the points made in those 2005, 2006 articles that I mentioned. The human body is not going to win that interaction, right? You are not going to be able to stop the mass and power of a vehicle. Knowing that you can't actually have that effect, why would you put yourself in the position of being exposed to that degree of danger? Just stay out of the way and you can approach the situation a little more safely.
And what would you say to an explanation that it was done either to convey to Ms. Young that she wasn't free to leave, or to be able to see into the vehicle?
Sure, and as I mentioned, both of those provide some tactical benefit. But when you already have one officer who's telling someone that they are not free to leave, standing in front of the vehicle doesn't add very much to that information, right? It's not like she was unaware of that until someone stood in front of the vehicle.
You can approach.
okay. So right now I'm looking at the civil suit that has been brought by the family of Takaya Young, where they are suing Connor Kroger's and the Jane Doe, the Kroger's employee. And I'm shaking my head. I'm bamboozled, not badboozled. Okay, let's get back to this before I say stupid things. So just for a thank you for watching in here, I wanted to let you guys know I got some really disturbing information this morning. This is not what I was posting about on X last night, but I was told this morning that the attorneys were really hoping that Connor would take a plea deal. And I don't know about you guys, but if you've been watching for the last couple days, or you've been like keeping up to date with just general overall highlights, well, I don't know what you're going to get from that with the mainstream media. But with that being said, I cannot think of worse advice. I don't, how is anyone going to find him guilty? How? And for his legal counsel to encourage him to take a plea deal, I think it was involuntary manslaughter, so he still would have done jail time. Like, I don't know about you guys, but when I was told that, I got like really worked up. Because imagine if he had done that based on what we've seen, which has been a complete freaking circus. The only way that he doesn't get off entirely is if there's one person, if it's hung. Like, I'd put money on that. And it would be because that person came in with a bias and was not paying attention to the facts, but rather working off of emotion. So there's one of my many pieces of information that I'm going to be sharing during this stream. So Patriotic just said something. He's having buffer issues with my stream. I am not seeing any issues on my end. Please let me know in the chat if you guys are having issues as well. I know there are issues with Cloudflare today, whatever the hell that means, which made my life a disaster, which is why we came on late. Okay, I'm not having issues either. Patriotic, what I did, if you have an iPhone, I saw that I was an update behind, and that helped. I was actually 2 updates behind. So, not sure if that's the issue, but it did help. Okay, guys, and welcome Flash Fan. All right, we're gonna get back to this, but stay tuned because I have even more information, kind of what I alluded to on X last night.
Professor Stoughton, don't testify as to what he was aware of and those kind of things.
Yes, Your Honor, I apologize. That was inartfully said. What I should have, and the way.
Is there a question being asked?
I would say, was that information already being communicated to you?
Yes, and an officer applying generally accepted principles would certainly be aware that that information was being communicated.
Objection, Your Honor.
And Professor Scobie, is your opinion in number 1, is that to a reasonable degree of professional certainty?
It is, yes.
And now moving to what is your second opinion?
The second opinion focuses on the decisions to draw the firearm and to use deadly force rather than remove oneself, Officer Grubb removing himself from that position in front of the vehicle.
In policing, to unpack that, in policing, when is an officer permitted to use some force?
So any amount of force, right? The goal of any amount of force is to address the threat presented by a subject's actions. Officers have a particular set of goals. They might have a situation, right? But it might be to stop someone, to investigate them. It might be to conduct a search. It might be to arrest someone. It might be to protect property, protect someone from being injured, etc. When someone's actions present a threat to one of those police goals, the officer can use force to address that threat. Policing defines threat in a fairly particular way. That is, a threat exists or a threat is imminent when the officer would reasonably perceive in that situation that the subject has the ability and the opportunity and the apparent intention to cause whatever type of harm we're worried about. Ability here really refers to physical capacity. Someone with a knife has the physical capacity to stab an officer, to cause that kind of serious bodily injury. Opportunity refers to whether someone is vulnerable to that particular type of harm. So someone might have a knife and have the physical ability, but if they're 60 feet away, they do not have the opportunity to inflict the stabby stabs that we're worried about with that knife, right? Intention is exactly what it sounds like. And we tell from the person's actions that it looks like they might want to inflict that particular type of harm. So someone who has a knife, who is within arm's reach of an officer, but they're chatting about burglaries in the neighborhood while the person is cutting up carrots for dinner, has the ability and opportunity, but not the apparent intention to use the weapon. All three of those components are necessary to establish a threat, because in the absence of any one of those, we have the potential for threat. We have what's referred to as risk. And officers have to deal with risk all the time. Every scene that they drive up to, someone could potentially have a gun, right? So we use tactics to manage risk, and the use of force is appropriate when the person presents a threat or an imminent threat of some particular type of harm.
So what are, under generally accepted practices, what are the steps in evaluating a use of force?
So the first is to look to see whether the officer has a sort of legitimate police goal. Are they trying to do something that they're allowed to do? The second is, okay, if the police have some legitimate police goal, are the person's actions in that circumstance, do they present some threat to that police goal? Are they going to delay or defeat the officer's attempt to investigate or apprehend? Are they going to injure someone, including the officer themselves, right? Once we identify that there's an imminent threat to some legitimate police interest, then we can say, okay, some amount of force may be justified here. It does not mean that any amount of force is justified, because the next question would be, if some amount of force is potentially justified, is the nature and severity of the force used appropriate or proportional to the nature and severity of the threat being presented? And this is sort of a sliding scale of severity, right? The more severe the threat, the more serious force officers can use.
And we've touched on this a bit, but what are the operative facts to be considered in evaluating the use of force?
So when you're talking about the operative facts, we really mean how should we understand that situation, right? Particularly if there are disputes about what the facts are. And the operative facts are the information that was reasonably available to the officer at the time. That is, if we take the actual officer and we pluck them out of the situation and we drop into the situation this sort of construct that we call the reasonable officer, what would the reasonable officer at the time have perceived and concluded?
And has policing also incorporated Supreme Court case law when it comes to the generally accepted practice in evaluating use of force?
Yes, absolutely. The idea of using that hypothetical reasonable officer as a construct, of using the facts as known to the reasonable officer at the time, that predated the Supreme Court, but the Supreme Court adopted exactly that framework in a 1989 case, Graham v. Connor, and policing adopted that same framework.
And so does that framework, considering the use of force from the perspective of an objectively reasonable officer, does that take into account specialized training, education, and experience that an officer would have that a layperson maybe would not?
It does, yes. The idea is what the officer would perceive and conclude, keeping in mind that officers may perceive things differently and may conclude things differently than non-officers. For example, a non-officer might view a particular interaction and say, oh, that's a weird little handshake. And an officer, on the basis of their training experience, might say that was actually a hand-to-hand drug transaction. But the reason that I know that as an officer is because of my training and experience as an officer. So we do use this framework not of the generically reasonable person, but the reasonable officer in that situation.
And Professor Stone, in this case, in evaluating the use of force, how do you identify the severity of the use of force?
So in this case, it's actually very simple, because we have the discharge of a firearm, and that is deadly force. Deadly force is any application of force that is substantially likely to result in serious bodily injury or death. Discharging a firearm certainly fits.
And is it generally accepted in policing that an officer can only use force if there's some type of imminent threat?
Yes.
And I think you actually answered in in part of one of your answers, when is a threat imminent?
A threat is imminent when we have that ability, opportunity, and intention. The way to think about that is it does not require someone to be actually stabbing an officer already. It doesn't require the person to have pulled the trigger on the gun. The officer is allowed to intervene and use force to prevent that from happening, but the person still has to have and display the ability, the opportunity, and the apparent intention to do that thing, right? So if we go back to the knife example, someone who's sitting in the living room talking with the officer and there's a knife across the room does not at that point have the ability. That is the ability to stab the officer. On the other hand, if they bolt for the knife and grab it, that's a pretty good indication that they now have the ability and potentially the intention to use that knife in the context of that situation.
And what is I think you also touched on this, but what is a risk as opposed to a threat?
Risk is just the presence of any one of those characteristics, ability or opportunity or intention, but not all three. And officers, one of my favorite quotes about this is, officers operate in risk soup. They're constantly surrounded by risks, which is why it's so important to use tactics to manage those risks and to prevent those risks from becoming threats, because threats are what give rise to actual harm.
And in determining whether or not a threat is imminent in policing, does that depend on the facts and circumstances of each particular case?
Yes, very much so.
And is that both from the United States Supreme Court and incorporated into the world of policing?
Yes.
And in evaluating the use of force, what portion of the encounter is reviewed?
All of it. You want to look at everything that led up to or potentially contributed to that use of force. Obviously, the subject's actions, because that's where we get our nature of resistance and threat, and also the actions of officers or potentially even bystanders that may have contributed to that.
So does evaluating the reasonableness of a use of force incident, does that involve evaluating decision-making from the beginning of the interaction to the end?
Yes, it certainly should.
Carmen, are you good? Let's see. Approach.
Yeah, I think we're going to break. Am I muted? No.
Carmen rules. We'll take a 15-minute break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it's finally submitted to you. 15 minutes.
All right.
Okay. So let me take these off. Okay. Hello, everyone. Good morning. If you are just now tuning in, thank you so much for being here. My name is Lacey Jane, and we are currently watching the trial of State of Ohio versus Officer Connor Grubb. And this was a shooting that took place on August 24th, 2003 at the Kroger's parking lot off of Sunbury Road in Westerville, Ohio. Officer Connor Grubb was a full-time officer with the Blendon Township Police Department, and he and a fellow colleague happened to be in the parking lot when this happened to help a woman who had been locked out of her vehicle. That is when they heard, did I say 2003? I meant 2023. That is when a Kroger employee came out and said that I needed to turn off comments. It's not you guys, it's me. I forget what I'm saying. I want you guys to comment. I just like when I'm trying to focus, I get all crazy. Okay. So this happened at the Kroger's parking lot, and the officers were like doing the whole window thing, like trying to get into the car and get the keys, right? And there was an employee that ran out of the Kroger's and said, this woman just stole a whole bunch of alcohol. And so one of the police officers, he was the contact officer in this case, he went up to her window and asked her to get out of the car approximately 11 times. By this point, the other officer, Connor Grubb, had made his way over as he heard his fellow colleagues saying, get out of the car, get out of the car, get out of the car. And the car was backed into a handicap spot. This woman did not have a handicap placard on. She had taken off her license plates, and she was refusing to get out of the car. The Kroger employee who had run out and said, hey, that woman just stole a bunch of alcohol, she was on one side of the car. The officer who initially made contact was on the other side of the car. And the only other place for Officer Connor Grubb to provide cover for the contact officer was in front of the car. And also to show, you're not going anywhere. We need to have a conversation at the very least. But at this point, they had been made aware that the Kroger's approximately 5 to 8 minutes away from here had also had someone steal a significant amount of alcohol prior in the morning. Sorry, guys. All right. So the officer placed himself in front of the vehicle, put his hand on the vehicle, and it was not until she turned on the car that Officer Grubb removed his weapon and had that prepared. He didn't know if she was armed. That's the other reason why the officer wasn't on the other side of the vehicle, because of crossfire. In these situations, you don't know, is this person armed? Are we actually going to enter a situation where we have to use lethal force? And so Officer Connor Grubb was standing in front of the woman, Takaya Young. And Takaya is at this point 21 years old. It was not known to officers when this happened, but she was 6 months pregnant. And she turned on the vehicle, put it in drive, began to move. And that is when Officer Connor Grubb, you can see in the vehicle, in the body cams, in the store parking lot footage, you can see all of this. He begins to get lifted off of the ground. And he eventually, after all of this is said and done, he is evaluated by Bureau of Criminal Investigation for the state of Ohio and an ambulance, EMTs, and you can see the injuries that he has on his shins and on his arms. And there is no way to deny that she was hitting him with her vehicle, a 3,500-pound Lexus. And you can see this happening, once he begins to look like he's going to be taken under the car, he lets off one shot. He hits center mass. And remember, she had put her car in drive, right? So she is immediately incapacitated. It is that in and of itself is a fatal gunshot wound. The car continues to go, like drift, until it makes it stops by crashing into the Kroger's right outside of the walk-up pharmacy, of all places. Thank God no one was standing there picking up their prescriptions. Side note, I was across the street when this happened, and I took photos. You can find those on my X account. I took photos of the response. I was listening to the scanner, and the state of Ohio, this is more of a Columbus issue. We have a lot of issues with our mayor and the elected officials in City Hall. with the FOP. They do not get along. I have been very outwardly in support of this officer. In no way, shape, or form was there any confusion that she was being given lawful commands. She decided to break the law that day. She was scared, I'm assuming she was scared of being taken to jail, not only because of the warrant out for her arrest, but this was the she was already on like a theft prevention program because she had a history of shoplifting. She had recently had a issue with her grandmother who has full custody of her other two children. She was not in a good place. She was not making wise decisions. I feel like that is a fair statement to make. And unfortunately, with the area that we are in, the leadership for which not we, but the city of Columbus has voted in, we have several cases right now involving police officers, either Columbus police officers or suburbs of Columbus, where these officers are fighting for their freedom for doing their jobs. Now, say what you will about the other cases, and we'll get to that later, but I genuinely, in my absolute heart, without a doubt, I am very, very supportive of the supportive isn't the right way. I understand the actions that were taken that day, and they were tragic. They were absolutely tragic. I don't think anyone disputes that, and my heart breaks for both families. But when did we start to live in a society where it is okay to not follow lawful commands and to shoplifting has always been a thing, but she already had been in trouble for it. She was a part of a program for people who had been in trouble for it. Like, there are just so many unfortunate items leading up to this. And we are watching this officer, former Marine, fight for it's extremely unfortunate. But I think that those who have watched every single day can agree that the state has very much struggled to prove that he is guilty of the charges coming for him. Murder and felonious assault, and it was not reckless homicide like I said the other day. I don't know why I keep forgetting the third charge. I will look it up, but I'm gonna let you guys, we're gonna press play because I need to look up something else to give you guys the next big piece of information. So that is the brief overview. If you have any questions, type them in the chat and I will do my best to respond. but during lunch, I will make sure that that I share some of the information that I received last night that has not been made public yet. I'm starving. I don't know if I should go grab something to eat really quick. All rise. You're welcome. Hey guys, do you remember Stoughton's first name? Is it Jeff?
Everyone can have a seat. Professor Stoughton, you're still under oath.
Yes, sir.
Make fire.
Thank you, Your Honor. Professor Stoughton, I believe when we left out, I was asking, in policing, when evaluating the use of force, what part or what portion of the interaction are you supposed to review?
The phrase that's typically used is totality of the circumstances. Totality of the circumstances review, we look at all of the contributing events that led up to it, the subject's actions, the officer, the entire set of circumstances.
So are an officer's decisions and actions leading up to a use of force considered in determining the reasonableness of the use of force?
They can certainly be relevant, yes.
And did the Supreme Court actually recently speak to whether or not the entire encounter should be reviewed when determining the reasonableness of the use of force?
It did in, I think, April. The court released an opinion in a case called Barnes v. Felix. So Barnes v. Felix addressed a Fifth Circuit, United States Court of Appeals for the Fifth Circuit rule called the moment of threat doctrine. And in that approach, the Fifth Circuit and one or two other federal circuits looked only at the time the officer used force or the moment immediately before that, right? The time when the officer pulled the trigger or the second or two just before that. The idea was that in the Fourth Amendment context, it was appropriate only to look at the moment of threat. And the Supreme Court reaffirmed its earlier decision in the 1989 case, Graham v. Connor, and said, no, in Barnes v. Felix, we do have.
One last thing. Sorry, guys, I didn't mention this earlier. If you are watching and you have been watching, or this is your first time and you are enjoying yourself, if you aren't already subscribed to my channel, please make sure to do that. Please make sure to like the video. And if you comment, just even with a simple emoji, that helps get more eyes on this. And this is a very important case with national implications in the area of law enforcement and policing. So you'd be doing me a major favor, and I greatly appreciate it. Thanks so much.
Have to look at the totality of the circumstances. We cannot, the court said something like, put on temporal blinders by artificially drawing the line. The court did not identify in the Fourth Amendment context the degree to which an officer's actions were dispositive, that is, the degree to which an officer's actions would make a use of force reasonable or unreasonable. But it said pretty clearly, we look at the totality of the circumstances without looking only at the split second in which force is used.
And Professor Stone, could you explain your analysis in arriving at your opinion that defendant's decision to draw his firearm and use deadly force instead of removing himself from the vehicle's path of travel was unreasonable and inconsistent with generally accepted police practices?
Sure. So opinion one is really about Officer Grubb's decision to put himself into the position in front of the vehicle. Opinion two is sort of taking as true that he has taken this position in sort of dead center in front of that vehicle. Now what? The idea in police tactics and the use of force is we want to use tactics or force in a way that will address the threat presented by the subject's actions. One way to address that threat is potentially to use force in a way that will remove the subject's ability or opportunity or intention to cause whatever type of harm we're worried about, that is to take away the threat. Another way to address the situations is to use tactics that can do the same thing. So when we're talking about someone who is in front of a vehicle, stepping out of the path of travel of that vehicle removes not the ability or maybe even the intention, but it certainly removes the opportunity. That is, the vehicle cannot travel sideways. So if you step out of the vehicle's path of travel, there is no more threat anymore. In this case, we see Miss Young sort of turn her steering wheel to the right, sort of just after that, where Officer Grubb draws his firearm. At that point, if we're anticipating the potential for there to be a deadly threat, right, for the situation to evolve in a way where there is the ability and opportunity and intention to use the vehicle as a weapon in a way that could inflict serious bodily injury or death, instead of drawing the firearm and standing there, get out of the way. Officer Grubb was in front of the car, by my count, a little over 10 seconds and more than 4 seconds after drawing his firearm. So there is ample opportunity to, either instead of or in addition to drawing his firearm, get out of the way of the vehicle rather than wait until the vehicle moves forward and then employ deadly force to address that threat.
Professor Stone, in your report, did you do a timing analysis of when exactly the different events took place during the entire interaction?
I did, yes.
Could you describe what we're looking at here in this diagram?
Yes, so this is a timing chart. And all of the times in that second column where it says approximately synchronized video, that is the runtime for the approximately synchronized video. That is all 3 videos put together. So I'm identifying specific events using that as the runtime instead of the various videos that make up that synchronized video. The event column specifies what happens, and that first column, sorry, the second column, approximately synchronized video, identifies when it happens. The next 3 columns are lapsed time. That is how much time has passed. The third column, the one that says lapsed time from previous event, just calculates the amount of time between whatever line it's on and the one immediately before it. So it's just counting up the amount of time between row 1 and 2, between row 2 and 3, not in a cumulative way, just individually. The fourth column, total lapsed time from Officer Grubb stepping in front of the vehicle, starts with event 2. Officer Grubb takes a position near the center of the front bumper and counts the total amount of time that Officer Grubb was in front of the vehicle. The fifth column, total lapsed time from Officer Grubb drawing his firearm, starts about halfway down the row that says Officer Grubb draws his firearm, and then counts the amount of time in those other events from the time when he drew his firearm. That is how long between he drew his firearm until the time that the shot was actually fired.
Based on your analysis, how much time was it total between when the defendant first situated himself in front of the vehicle to when the shot was fired?
10.467 seconds, almost 10.5 seconds.
And how much time was it from when Takaya first inched her vehicle forward to when the time that the shot was fired?
So the first inching of the vehicle is about 3.5 seconds. And the way that I'm getting that is I'm looking at Miss Young's vehicle moves forward and then going down to Officer Grubb fired.
And then how much time was it between when the defendant first drew his firearm and when he fired?
4.334 seconds. That's that last number all the way on the bottom right.
And how much time between when Takaya is first seen turning her steering wheel to the right and when he fires?
So that is right about just over 5 seconds, 5.033 seconds. And what I'm doing there is looking at the second column, going to the third number down, 14:10:966, and then going down to 14:16:1.
And Professor Stone, based on your timing analysis and your review of the case, what is your opinion?
There was ample time for Officer Grubb to remove himself from the front of that vehicle. Again, even assuming that he put himself there, right? Ignoring that piece, there was ample time for him to remove himself from the vehicle, starting at the time he put himself in front of the vehicle. But even looking at when Miss Young rotated the wheel, when Officer Grubb drew his firearm, and sort of subsequent events, there's ample time to take the couple of steps that might have been necessary to get out of the path of travel of that vehicle.
So he just wanted her to drive away with over $500 in stolen merchandise for the second time that day, and without the ability for officers to locate her. Cool.
And Professor Stone, what is the generally accepted position on shooting at a moving vehicle?
Yeah, so that's a good question. Generally in policing now, Officers are instructed to not fire at a moving vehicle when the vehicle itself is the weapon. That is, we're not talking about someone who's shooting from a vehicle. We're talking about the vehicle itself is being used as the weapon in most circumstances. Small caveat, there is developing an exception for when the vehicle is apparently being used as a weapon in a potential mass casualty event, like driving into a crowd or something like that. But outside of that circumstance, officers are generally taught to not shoot at a vehicle when the vehicle itself is the only weapon, because shooting at a vehicle is highly unlikely to actually have the desired effect of addressing.
They didn't know that that was the only weapon. They didn't know that she didn't have a gun.
The threat presented by the moving vehicle. That is, if you shoot at the driver and miss, or you shoot and just injure the driver now has additional motivation to get the hell out of there. If you shoot and disable the driver of a moving vehicle, that is, let's say you instantly incapacitate them, you've now just created an unguided missile. You haven't stopped the vehicle. There's no way physically for the little tiny mass of a bullet to arrest the momentum of a vehicle. So you haven't actually addressed the threat presented by the moving vehicle, and you may have made the situation dangerous by incapacitating someone who would be able to drive that vehicle.
If a person is right in front of a moving vehicle, is shooting the driver likely to prevent the vehicle from hitting that person?
No.
And does this case illustrate the possibility of then an uncontrolled moving vehicle being the result?
Yeah, the vehicle kept moving after the shooting here. The vehicle kept moving and crashed, and that is the risk, or that is one of the main risks of shooting at a moving vehicle, where again, if incapacitated, the driver has just lost the ability to avoid, the proverbial lady with the stroller that they would have otherwise avoided.
And is there a concern about how bullets interact with hitting vehicles or the windows of vehicles?
Yes, I mentioned earlier, kind of any object has the potential to throw off bullet trajectories, right, to create ricochets. That's especially well known with auto glass. That's especially true with auto glass. Like, we can't predict with a great deal of precision where bullets that hit glass are going to go.
And Professor Stoughton, is this generally accepted principle that shooting at motor vehicle is rarely effective? Is that frequently reflected in peace officer curriculums?
Yes, training, often in policy statements, yes.
And is there a time, according to generally accepted practice and principles, where it would be deemed reasonable to shoot at a vehicle?
Yes, absolutely. So one example would be when it's not the vehicle itself that's being used as a weapon, but instead someone in the vehicle is using a weapon that has to be addressed through the use of deadly force. Someone in the car, for example, is shooting at officers or others. I already mentioned the potential for a vehicle in a mass casualty event. The other possibility is when there is no feasible option to address the threat of being hit by the moving vehicle. And maybe the clearest example of this is an officer who's standing in a narrow alleyway between buildings and the vehicle is coming at them. There is no opportunity, excuse me, I should say that differently. There is no chance for the officer to reposition in a way that deprives the person of the opportunity to hit them, right? They remain vulnerable to being hit. In that situation, shooting the vehicle is still not likely to actually stop the vehicle. It's still not likely to be effective, but it's the best option that we have under the circumstances. So it's not likely to be effective, but it is more likely to be effective than doing nothing at all. So in that sort of limited situation, and the way that we see this in most policy guidance is directives for officers to not shoot at moving vehicles unless there is no feasible alternative to doing so, no way to get out of in front of the vehicle.
I have no further questions. Thank you, Your Honor.
Ladies and gentlemen, we're going to take a 5 to 10 minute break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it's finally submitted.
All right. Okay. So let me forget to put that back on the screen once it starts over again. So I am looking on the docket for this case. And here, let's go ahead and. So this is her sister. The the Takaya Young, the woman who was shot. That is her sister, who was there the night or the day that she was with her in the store at Kroger's. Findings of fact and conclusions of law relating to the state's motion regarding Kevin Davis. Who's Kevin Davis again? Okay. That was the officer from Akron. And that was brought by the defense. Because I'm wondering if that resulted in what I know. I have a message to someone right now asking if they have paperwork for me to share what I know. I do not know the officer, but I know the EMTs who responded. Just I'm not friends with them. Like, I know them. One helped me in my car accident. And then I am same situation with some of the other police witnesses that were called. Hold on one second. I had to watch the San Antonio case on KSAC because they didn't allow anyone content creators to stream with commentary. Huh, that's interesting. I haven't been yelled at by anyone. Yay, no buffering. So my husband just sent me all these texts about this whole Cloudflare thing. And it causing internet outages today. When I say, you guys, that I was like a bloody mess this morning when I woke up and I couldn't access like my live streaming platform. X was down. The docket, I couldn't get into the docket. I was like, knowing that I could not control it, keeping that in mind, I was nevertheless, I was a mess. I was so like, today of all days. So let me pull up the message that I have been sent. Oh, you must be watching. The person whose message I was just looking at just texted me back. So depending on how the testimony goes today on some of the, and I can only assume it's based on how the defense is feeling, watching the jury's reactions, so on and so forth. There is a very high likelihood that we could see closing arguments very soon. It was suggested to me that it might be today. I don't believe that to be the case. I don't think the judge is dumb enough to start closing statements and not finish them. I can absolutely see them beginning tomorrow. Because you typically want to do it back to back and not have like a night to think about it. And the other piece of information that I have not been able to find backup information on. So oh, I guess you guys will have to wait. Which is actually fine by me because I am starving. So give me a moment. I will be right back and we can discuss what I've heard. I've got to switch cameras really quickly.
Yes.
Okay. Can you read this head note for us, sir, starting with, actually just read the whole entire head note. Graham's probe, starting with Graham's prohibition.
Sure. So head note 17, law enforcement officials, excessive force. Graham's prohibition from using the 2020 vision of hindsight extends to the testimony of even most of the erudite police procedure consultant when it crosses into the prohibited territory of second guessing and armchair reflection. This includes comparative speculation, couched in backward-looking terms, about what an officer could have done or might have done differently, or whether he should have employed alternate or lesser means of force or different tactics.
Thank you, Professor. It says 4 different tactics, correct?
Yes.
Now, redirecting you back to the computer with back to your opinion. Your second opinion is that he should have used a different tactic to get out of the way of the vehicle. That's what you just testified on direct examination to these ladies and gentlemen of the jury, right?
Yes.
But
That his tactic of remaining in front of the vehicle and drawing his firearm was professionally inappropriate. Yes.
But the law says that what an officer could have done, might have done, or whether he should have employed different tactics is comparative speculation. That's what the quote that you just read to the ladies and gentlemen of the jury said.
Sure, and I will leave it gracefully to the judge to instruct the jury on what the law is. I'm not here to apply Ohio state law. I'm not an expert in Ohio state law. I'm an expert in generally accepted police practices. To the extent that Ohio state law differs from my focus as a policing expert, that's kind of up to somebody else to figure out, not me.
So you testified on direct examination, though, that generally accepted police practices certainly come from state law, correct?
I would say that they are typically informed by a combination of law. My specific testimony was about Fourth Amendment law, but state law should also inform generally accepted practices in that jurisdiction.
And so you're an expert here in the state of Ohio and you don't know what the state of Ohio's laws say?
That's not what I said.
I'm asking
About what?
about looking backwards, about using hindsight in order to determine if an officer should or should not use a different tactic.
Yes,
Okay.
I'm familiar with the case and just read a head note, which of course is not the text of the case, it's the head note.
Do you need some time to read the entirety of the case, sir?
No,
Okay, thank you. Now, you're not a practicing lawyer, correct?
that's correct.
A practicing lawyer is someone who passes the bar, right?
Well, that's a necessary prerequisite. I've done that.
But you choose not to practice. You're not doing that.
Correct.
Now, either way, you've certainly spent a lot of time in the courtroom before, right?
Sure, I think that might depend on how we define a lot, but sure.
You've testified in over 15 cases, I think you said on direct examination, 18 to 22 cases.
Yeah, something like that, plus more in depositions and the like, yes.
So you've been in the courtroom a lot, right?
Yeah, sure.
And based on your experience of being in the courtroom, you know it's my job as the practicing lawyer to ask questions, right?
Yes.
And it's your job as a paid opinion witness to answer those questions. True?
As a witness generally, sure.
Sure. Now, if I ask a question that you don't understand, do you promise to let me know so I may ask a better or clear question?
Sure.
Thank you so much. And do you agree to answer my questions in the way that I ask them rather than another question that's not being asked?
I'm sorry. If you're asking me if I can answer your questions, sure. If I understand the question, I will answer the question that I understand you to be asking.
Sure. And if you don't understand, you'll let me know.
Yes.
And you'll answer the question as I pose it to you. Yes?
Sure, unless the answer would be manifestly misleading of some part of my testimony or opinions.
Sure. You can answer my question, so yes.
I hope so.
I hope so too, sir. And if you answer a question I didn't ask you, that will force me to re-ask you the original question, and that would waste everyone's time, won't it?
Probably.
So if I asked you what state you're in today as you're sitting here testifying about what a police officer did here in this state, how would you answer that?
I am currently in the state of Ohio.
Thank you, sir. Now, you kind of went over this on direct examination about you being paid to offer an opinion, correct?
I'm compensated for my time. I'm not paid for my opinions.
Okay. Well, certainly fair to say that if you didn't give these guys the opinion that they wanted, you wouldn't be on the stand testifying?
Yeah, that's probably correct.
Okay, so you gave them the opinion that they wanted, and now you're here testifying.
No, I gave them the opinion that my review led to. The fact that it's helpful to them is irrelevant to me.
Okay. So fair to say that prosecutors work for the taxpayers?
Sure.
And you were
I would
hired-
I would say broader than just taxpayers, right? They work for the public generally, regardless of whether they're taxpayers or not.
Sure, but certainly taxpayers are included in that?
Yeah.
Okay. And you were hired by the prosecution, right?
Yes.
Okay, so taxpayers fund the state of Ohio's budget, yes?
Yes.
And so you would agree with me then that the taxpayers are paying you $415 an hour to evaluate this case, yes?
Sure. Through an attenuated series, sure.
Okay. And I think you testified on direct examination, you believe you've spent maybe 30 to 35 hours that you have billed the state of Ohio?
I think that's right. I'd have to look at the invoices on this case to confirm that, but I think that's about right.
It's just an estimate, 30 to 35 hours?
Yeah, probably something there.
Okay. So at 30 hours and $415 an hour, the conservative estimate is you've billed about $12,450 to date, yes?
Sure. That sounds about right mathematically.
And if it were 35 hours, you would have billed $14,525.
I cannot do that math in my head, but sure, that sounds about right.
And you're testifying today, you've been on the stand for over 2 hours, but you billed for 8 hours of testimony, no matter how long you're on the stand. Is that correct?
I bill at a minimum rate of 8 hours on days of testimony. Today I'll be traveling as well, so it'll be more than 8 hours today between testimony, the actual hours of testimony and travel.
Okay, so more than 8 hours. About how many do you think you'll bill per day?
I don't know. It depends on when we end and how much downtime I have between like getting to the airport and getting home.
That makes sense. But let's just call it 8 hours for conservative purposes, knowing
Sure.
that you're going to bill more than that. So that's an additional $3,320, true?
Yes, plus travel yesterday.
Thank you. And all of us think about work while we're doing other things like doing laundry or driving. Would you agree with that?
I try really hard not to think about work when I'm doing other things.
That's fair.
Um,
But certainly it creeps in, right?
It can.
Do you think that you probably have spent time that you haven't billed for, in addition to the time that you have billed for thinking about this case?
Sure. I'm sure there were like short phone conversations here or there, or like things like that, where it wasn't just thinking about the case, it was like actually working, and I just don't bother to bill because it's not worth it.
So fair to say total at the end of all of this, you'll probably have put at least probably close to 40 hours into this case?
Sure, that seems fair.
And while you were preparing your report to form your opinion, how many different angles of the incident did you review?
So there are 3 different cameras of the incident itself that best capture the incident. There are more security cameras from Kroger that informed the angles, but not to the degree that they actually captured a lot of relevant information.
Did you review that camera though also?
Yeah, I reviewed all of the videos that I have.
So you would agree with me then you've at least reviewed 4 angles. The RX video walk-up,
Yep,
the Kroger security camera footage,
the outside one, yes.
Grubb's body-worn camera,
Oh, yes,
and Moynihan's body-worn camera.
yes.
So you reviewed 4 different angles before coming to your conclusion, correct?
At least that. I think there were actually more, but it's at least that many, yes.
Now, you know a lot about body-worn cameras, right?
Yes,
And you would agree with me when I say that these cameras can sometimes be outright misleading, yes?
absolutely.
Now, it's possible, sir, that some opinion witnesses in court cases bring biases with them into their work, right?
Sure.
In fact, you would agree with me that certainly everyone has certain biases that color their interpretation of the world around them, true?
Sure, that is the nature of the human experience and cognitive bias, yes.
And an opinion witness with a very strong bias could use his platform to unfairly affect a jury. You would agree with that, right?
So no, I think you're confusing their bias and advocacy. You can separate those. A witness who's biased may affect their conclusions. Regardless of bias, a witness could inappropriately engage in advocacy, but those 2 things aren't necessarily related.
So is it your testimony today that a very strong biased opinion witness could not use his platform to attempt to unfairly affect a jury?
No, I just think those are separate things. Like that doesn't have to be the result of bias.
Okay, so that's not my question. I'm asking you particularly with respect to bias. Do you think that opinion witnesses can come in here and unfairly affect a jury with their biases?
Can you define what you mean by unfairly, right? Because the point of the adversarial system and a judge's instructions or limitations should address that unfairly point.
Correct.
If a trial is being well managed, then no, it wouldn't be unfair. It would be within the scope of a trial. If it's not, then sure, I suppose that could be unfair in some way, but it might depend on what you mean by unfair.
You're aware that the judge is going to give this jury an instruction saying, do not let your biases creep into the back of the jury room.
I am not going to presume to guess anything about the judge's instructions to the jury, but that would be a pretty standard instruction.
You would agree with that, right?
Yes.
And so if a witness comes in here with bias, you're saying that that bias can't somehow bleed into the jury deliberating.
No, I guess I'm confused when you're focusing on unfair bias, right? The point of the adversarial system is to address the limits of unfair bias and to prevent a witness's, let's say, unfair statements, right, from being considered or adopted into the jury room.
And our statements, our system is perfect?
Hardly that.
Okay, so it's possible then that biases could affect what is presented on the witness stand, correct?
Oh, sure. Yeah, I agree with that.
Thank you. Now, do you have a copy of your CV up there just in case?
I do not.
Okay. Would you like a copy of your CV? Because we're going to talk about the cases that you've testified in at trial.
Sure.
May I approach the witness, John? This is a copy of your CV, Mr. Stoughton. I tabbed in green where you start with your case citations.
Okay.
Okay? So, I'll let you there. So,
All right.
for police use of force cases where you've actually testified and given trial testimony like you are doing today,
Sure.
let's start naming the cases in which you've given an opinion that stated that the police officer's actions were contrary to generally accepted police practices. Go ahead.
In trial testimony.
Yes, sir. In trial testimony.
Okay. So the first one, this is an older version of my CV. The first one is People v. Sean Grayson.
You said Grayson?
Grayson, yes. Grayson.
Okay.
Trial testimony.
Yes, sir.
The Christian Glass case in Colorado.
What others?
I'm sorry.
I'm sorry. I said what others?
Taylor in Texas. Mead. Nigro, Nigro. Glass on the civil side. Herndon, Herndon. Schurr, Schurr. Potter. Chauvin. Coy. Jones. Rhines, Rhines. Rhines. Smith. Calmer, Calmer.
And that's one where the defendant shot and killed 2 police officers, true?
No, he shot and killed 1 officer.
Okay, but he shot at 2 police officers?
I don't know. There were 2 police officers there. I don't think he shot at more than the one.
Okay, so he killed a police officer.
He did.
Okay.
That's what I have.
What about Grayson, sir?
That's the top one on there.
Oh, I apologize. I'm so sorry. Norton? Did you testify in the Norton case?
I did, not with an opinion finding fault with the officers, which is what you asked about.
So these are all the opinions that you've testified in for a finding fault with the officer, true?
No, I understood your question to be, these are the cases in which I've testified at trial, in which I've had an opinion finding fault with the officers.
That's correct, sir. That's
Yes,
what I asked.
yes.
Okay, so how many?
That's exactly what he freaking said.
In trial, given trial testimony
She said.
that you found not at fault with the officers.
Almost all of those cases also have opinions where the officers did things appropriately.
Sir, I'm talking about your overall general opinion. When have you testified in trial on behalf of a police officer?
You mean without finding any fault at all with the police officer?
Sir, that the police officer hired you
Oh, well,
in trial.
okay. So you're asking about cases where I've been retained by whoever's representing the officer, and I've testified in trial without any opinions negative to the officer? Is that what you're asking?
Yes.
That's a series of limiting considerations. Let's see. I don't think all of those conditions have lined up. I don't think I've done any cases where all of those things are true and nothing else.
Thank you, sir. Now you teach law students, true?
Yes.
Are you aware of a national website called Rate My Professor?
I have heard of it.
And these law students that you teach,
I feel much better, thank you. Sorry to have disappeared.
these law students that you teach certainly spend a ton of time with you, true?
Your Honor, I would object at this point. The state hasn't seen this, isn't familiar with it.
You haven't seen
Yes,
Rate My
students spend,
Professor?
probably more time than they want with me.
How many credit hours do you teach?
I have criminal law is 3 credits this semester. Criminal procedure is 3 credits. My police law and policy class is 3 credits. Regulation of vice students can take as either 2 or 3 credits. I also supervise legal research projects.
And so for the credits that they spend, they have to spend X amount of hours, or in order to achieve those credits, they have to spend X amount of hours. You would agree with that, right?
Yeah, I think the ABA actually regulates by minutes, but yes.
Would you be surprised that at least one of your law students believes that you're not an expert in police self-defense?
I would be surprised if we could identify that anyone who rated me on Rate My Professors is one of my students. There's no verification.
Well, actually, sir, there is a verification. Are you aware of that verification process?
Yes, in some sense, but no, not
What?
specifically.
What?
One of your students here says it's difficult to understand how someone who had only worked as a police officer for 5 years could be considered an expert in the area. As the saying goes, those who can do, those who teach can't. That's true, right?
Which part?
That's what it says, yes?
Yeah, that's what it says. I don't know what SCHC 388 is. That's not a class I teach.
So that's not what I asked you. That's what,
That is what, yes, that is what someone's anonymous comment says on the internet. Yes.
Okay. Well, it certainly says that you worked for a police officer for 5 years, right?
Sure.
That's an intimate detail about you, true?
No, that's widely available on like the internet all over the place,
Okay, so.
including on my faculty bio. I don't talk about that in class.
Okay, you don't talk about that in class.
No.
Okay, that's fair. Let's see here. Professor Snowden is a politically charged narcissist. That's what this review says.
Your Honor, I would object again. These are just random comments found on the internet by unidentified people. This is not appropriate.
Thank you, Your Honor.
Let's
That's-
go.
That is what it says. And Laws 672 is a class that I teach,
Okay.
I think.
All right, this next one says, made memes of himself to try to appear hip, shoehorns his personal politics into every discussion. Very unprofessional, right?
That's what it says. I can tell you I have never made a meme of myself, although sometimes students will make memes of me and pass it around.
And this says it was reviewed April 12th of 2021, right?
That's when it was submitted, yes. So that's, it also says A+. It's not a grade that we can assign at my school. So I don't know who's, like, that's just not accurate.
Again, sir, I'm not asking you who wrote this review or anything like
That's
that. I'm just
good.
asking
I have no
you-
idea.
I'm sorry?
That's good. I have no idea.
Okay, yeah, all I'm asking you is that certainly this is on, is a publicly available website, and it's got this review that says you shoehorn your personal politics into every discussion, correct?
It does. Other aspects of that make me think that I haven't had a discussion with that person, since it says no textbook and my classes involve textbooks. It says A+, and that's not a grade that I give. It says not mandatory for attendance, and all of my classes are mandatory attendance.
That's right, so some internet troll just got on the internet and just decided to destroy your reputation here.
I mean, if you look at the timing, this is around the time of the Chauvin trial. That may very well be the case.
Now, thank you, Ms. Cook. You live in South Carolina,
I do.
and more than 20 years ago, you were a police officer in Florida.
Correct.
But you're here today to talk about what a police officer did here in the state of Ohio, true?
Yes.
And
Yeah,
as
ma'am.
a paid opinion witness, you've already admitted to the ladies and gentlemen of the jury that you don't know a lot about Ohio law, right?
So having nothing to do with being compensated for my time, I do not apply Ohio law when I'm here as an expert to talk about
Don't
generally
fight
accepted
me.
police practices.
You realize that police enforce the law, right?
Yes.
Okay, so, and you're testifying here today, again, as a paid opinion witness on behalf of these prosecutors, but you didn't review any Ohio law before coming into court to testify.
I'm not answering legal questions with my testimony, so no, it would be inappropriate for me, like it would be for any witness, to offer a legal conclusion.
I'm not asking you for a legal conclusion.
Ah.
The jury to know the answer to my question,
I think I'm answering your question.
I don't.
It would be irrelevant for me to review Ohio law because I'm not offering an opinion that backs itself or grounds itself in Ohio law. I'm applying generally accepted police practices. It would be a little bit like, did I review a cookbook? No, because that's irrelevant to the opinion that I'm actually generating. Now, Ohio law is clearly relevant to what the jurors are being asked to do, but I am not a juror applying Ohio law to the facts of this case.
Connor Grubb has to enforce Ohio law, sir, correct?
Sure,
Okay, and you didn't review that Ohio law before coming into court to testify today, yes or no?
that's correct, because it wouldn't matter to my opinion.
Shut up!
Thank you so much, sir, for telling me that Ohio law doesn't matter to your opinion. I appreciate that.
Sure.
Now, you don't know what Ohio law says about when a police officer can use deadly force?
I'm sure I do. I've written about it elsewhere. It's just not relevant to my opinion in this case.
Can you name the Ohio Revised Code section that permits officers to use self-defense here in the state?
Do you mind if I refresh my memory?
Not at all. Take your time.
Also, I need reading glasses. My eyes just realized they were in their 40s.
I got a reader back in my office.
I didn't expect to need to read. Boy, they print these books really tiny. So we have a table of cases and state statutes in the opinion, in the book. One of the chapters is about the state law standard. I'm sure I don't know what it is offhand, but I'm sure I looked at Ohio law at the time because I looked at the law in every state at the time for writing the state law chapter.
I'm talking about before testifying today.
Yeah, I wrote the book before testifying today.
What book when? What year?
I wrote the book starting in probably 2017, 2018. It came out in 2020.
It's 2025 now.
It is.
You were never certified as a police officer here in this state, correct?
That's correct.
Thank
Training
God.
A quarter of a century ago is certainly not the same as the police training that Connor would have received more recently.
Boy, I hope not.
On direct examination, you talked about your education and experience, true?
Yes.
Your undergraduate degree wasn't in criminal law, wasn't in pre-law, wasn't in criminal justice, it was in English literature, true?
Yes.
And before you even finished college, you said you spent a few years as a full-time officer in Florida?
I'm sorry, ask that again?
Before you finished college?
Yes.
We have entered the realm of fuckery, which means the wig comes out. Enjoy.
You spent a few years as a full-time officer in the state of Florida?
Yes.
You said under 5 years?
I was full-time for about a little over 4.5 years, and then part-time for another 6 months. So yes.
And in those 4.5 years, you never worked for internal investigations, correct?
No, I did that when I left and went to a state office.
You never were promoted to sergeant,
No,
definitely never promoted to a lieutenant.
no, certainly not.
You chose to leave police work again for academia, true?
No, I left police work to go to law school and then eventually made my way into academia.
Sure. So eventually made your way to academia.
Yes.
Great. Now you testified at grand jury in this case, correct?
Yes.
Now, as a law professor, you're aware that in the grand jury, there are no rules, true?
I wouldn't say there are no rules, but I would say that it's a very different set of rules than applies in trial.
Well, there's no judge, right?
Correct.
There's no me or Mr. Collins as defense attorneys, true?
Yes, that's correct.
There's no rules of evidence that applies, true?
Broadly, yes.
Okay. This case had to be presented to the grand jury before an indictment came out, right?
Yeah, the grand jury is the one that indicts, so yes.
Correct. And not just anybody can show up and say, hey, I've got some information for the grand jury. Can I testify,
Your
right?
Honor, object again, they shouldn't consider the indictment for any purpose.
Councilwoman approach.
Thank you.
Trying to see what we can hear.
Sorry, sir. I was saying, so nobody can just show up to the grand jury and say, hey, I've got some information for you. Let me testify, right?
Do you mean the prosecutors call the grand jury witnesses? I'm not sure what you're asking.
Any random citizen can't show up to the grand jury and say, hey, I've got some information I would like to testify right here, right now at the grand jury.
I mean, they can approach the
Oh my
prosecutor
God,
and say
just
that.
answer
Whether or
the
not they get to is up to the prosecutor calling them as a witness.
Sure, it's up to these guys who to call as a witness at the grand jury, right?
Mhm.
Just like it's up to
Sorry,
them
yes.
who they get to call during their case in chief, true?
Yes.
Okay. You would agree with me that you were called to testify by these prosecutors at the grand jury, yes?
Yes.
And you were retained by these prosecutors on April 29th, 2024, correct?
I'd have to go back and check the date, but I think that's right.
I can get the date for you, sir. Do you remember testifying at the Daubert hearing?
I do. I just don't remember the specific date, but I'm happy to accept your representation that that was the date of retention.
Appreciate that. So that's April 29th, 2024, true?
Sure.
Are you aware of when this case was indicted?
No, I don't remember.
You don't remember us talking about it at the Daubert hearing either?
Not offhand.
Okay. So if I told you, would you accept my representation that it was not indicted until August 13th of 2024?
Sure.
Okay, so you were retained by them though in April, right?
Yes.
And you testified at the grand jury before the charges came out here, true?
Yes.
Your report was dated July 31st, 2025, correct?
Yes.
Now, when you testify or write reports as an opinion witness, you testified on direct examination that the term of art that you choose to use is officer created jeopardy, true?
As a way of referring to unjustified risk taking, yes. I use a couple of phrases. That is one of them. Sometimes I just use the phrase, as is mentioned in this report, unjustified risk taking, unsound tactics. The point is similar with all of those.
I'm talking about just in your conclusion though, you only use your term, officer created jeopardy, true?
I mean,
your
in opinion
conclusion?
one,
Yes, sir.
I mean, I describe it as unreasonable, as contrary to generally accepted police practices, as officer created jeopardy, and as foreseeably contributing to the shooting.
Sure. Can we just pull the computer up? I'll pull the slide up for you.
Sure.
Where it says officer created jeopardy. That's the term of art that I'm focused on for the line of this questioning, okay?
Sure. Yes. I also use that term. Yes.
Do you understand? Oh my God.
You see where it's highlighted in yellow?
Yes.
Constituted officer created jeopardy. True?
Yes.
Now you're aware that the Supreme Court of the United States has held on the use of deadly force, has listened to a couple different cases. True?
Yes. A number. Yes.
Okay. Tennessee versus Garner is one.
Sure.
Graham versus Connor is the other.
It is another, yes.
Scott versus Harris is another, true?
Yes,
Now, you testified about how the case of Tennessee versus Garner, the facts of that case, do you remember that?
yes,
About shooting a fleeing felon, true?
yes,
Okay, but the facts of that case certainly don't mirror the facts of this case, correct?
yes.
Okay, you would agree with me that Connor Grubb got hit by a car, correct?
I have no opinion as to whether he got hit or not hit by a car. He was certainly in front of the car when it started moving.
Sir, you can see on the video that he gets hit by a car, no?
I can't see on the video a point of impact. I'm not saying he didn't get hit. I'm
Oh
just saying
my
I can't
God.
testify to my degree
Oh
of
my
expert
God.
certainty in my area that he was struck by the car. Was there contact? Absolutely, there was contact. He put his hand on the car, among other things. But I don't know whether he was impacted or hit.
I'm just asking you to use your eyes, sir. I'm not asking for any expertise or anything like that about generally accepted police practices. Just watching the video, you're telling these ladies and gentlemen of the jury here that Connor Grubb did not get hit by a vehicle?
If you're asking for a lay interpretation of the video, that's up to the jury. I testify as an expert. So to a degree of expert certainty, I can't define that he was hit or not hit. That's also not really the point of any of my opinions.
Sir, I get to ask the questions. Remember, we established that on direct examination, right?
On cross.
Examination, yes. And is there a reason why you don't want the members of the jury to know what it is that you see on the video, whether or not Officer Grubb gets hit by a vehicle?
I am happy to talk about that,
I would just like.
but the jury gets to decide what the facts are, not me.
Did you review the video?
Yes.
Did you see him get hit by a car?
I did not see a point of impact. I saw his hand on the car. I saw what looks like plausible contact. I have reports that say that he was hit by the car. I have at least some evidence suggesting not. It's not the job of an expert to resolve factual disputes. So-
That wasn't my question about what the job of an expert is. I'd really like you to stop wasting time and just answer the question that I asked.
You're asking a question that is outside the scope of my expertise.
You can't use your eyes?
Sure, I can watch the video and I can tell you, I don't know from the video, having watched it a great many times, whether Officer Grubb got hit by the car or not. I see his hand on the car. I see what plausibly could be contact between the car and his leg. I also see what plausibly isn't necessarily. I don't know, and I'm not going to testify to a reasonable degree of professional certainty since I'm here as an expert about what happened when I don't have a good basis for it.
Not what I'm asking you again, sir. All I want to know is, did you see Connor Grubb get hit by the car? Yes or
Your
no?
Honor, he's answered the question at this point.
Council Brook,
Oh, thank you. Let's get some answers without arguing. Sir.
Now, you've never been a judge, have you?
No.
Certainly never a Supreme Court justice, right?
No.
Judges shape the law. You would agree with that, right?
Sure.
You went to law school, though, so you would agree with me that when the Supreme Court makes a ruling, every court in the country must follow that ruling, true?
Depends on the nature of the ruling. If the court is making a ruling and it's exercising its administrative power over the federal courts, no, it wouldn't apply to state courts. If it's a constitutional ruling, yes.
Okay, so as long as it's applicable, when the Supreme Court speaks, the states follow.
Yes.
Ohio courts have to follow it, true, too?
Sure. Anything that is applicable to constitutional rights or the like, yes.
Even the judge in this case, if the Supreme Court makes a ruling that's relevant to this case, this judge has to follow that, true?
Sure. If there's a relevant ruling, yes.
Mandatory directives from courts are very serious things, right?
Sorry, say that again. Mandatory directives from courts, like injunctions?
Mandatory directives like the law. When the Supreme Court articulates the law, that's serious, true?
Sure.
You would agree with me that the U.S. Supreme Court in Graham versus Connor said that those who evaluate an officer's use of deadly force, people like you and the jury, must not use hindsight 2020. True?
Yes, I think they say avoid the 2020 vision of hindsight.
Thank you. Now, you would agree with me that it's this judge's job to give the law to the jury, yes?
Yes.
And whatever is in those jury instructions, this jury must follow.
I really don't want to get into any position of instructing the jury, but yes, the jury should follow the jury instructions.
Thank you. Now, I've actually sent you a couple different sets of jury instructions that we've used over the past couple times we testified, yes?
In previous cases?
Yes, sir. You don't remember receiving an email from me with prior jury instructions from this court?
Which case was that in?
The Meade case, the Coy case, I've sent you Mitchell jury instructions before.
Um,
I've got the email if you would like to see it.
yeah, yes, it sounds familiar.
Okay. Now, nowhere in any of these U.S. Supreme Court cases does it mention your term of art, officer created jeopardy, correct?
Those cases do not use that exact phrase.
And in the jury instructions, nowhere in the jury instructions that
Ah,
I have
these
seen from
headphones.
prior cases does it mention the term of art, officer created jeopardy, correct?
Sure, the jury instructions do not use that exact phrase.
And actually in OPATA, the training materials that you reviewed, nowhere in those training materials does it use the words officer created jeopardy, correct?
Right, it does, it certainly reflects the concept, but it does not use that particular phrase, yes.
And you also testified in another case as an opinion witness. Do you remember the Taylor v. Holtmeyer case?
I do, I think that was limited to deposition testimony.
Okay. And that court was a federal court, true?
Yes,
And that court held that your opinion regarding the use of deadly force is inconsistent with the Supreme Court's opinion in Scott versus Harris, correct?
sure.
Now, I want to talk to you about your report, and actually testified to this on direct examination. You stated, it is well known and generally accepted that time is the single most important tactical concept in policing, true?
Yes,
Okay. Now, you say that time is the most important tactical concept, so you're talking about the present tense, yes?
yeah,
You're not talking about from a quarter of a century ago when you were a police officer.
then too,
But you're certainly talking right now, true?
yes,
As you sit here today, you believe time is the most tactical, important policing concept, yes?
I think, sure, today, yes, absolutely. I don't think it's just today, right? I think it's actually a very old observation.
I understand. So did you take a poll of all police officers in America to determine that this notion is well known?
No, I reviewed training material, use of force policies, tactical guidance, tactical training manuals going back to the 1970s.
So no, you didn't take a poll.
I did not take a poll.
And did you take a poll of all police in America to determine that this notion is generally accepted?
I did not poll. No, this is not survey research.
Okay. So you have a footnote citation there, true?
Yes, that's a citation to my book.
Your book,
Yes.
not all of these 1970 policies or anything else you just told the ladies and gentlemen of the jury about. You cite to yourself, true?
Well, those are cited in my book.
So that's not what I asked. You cite to yourself, correct?
Yes.
I feel like I'm
I
going to stroke
cite to
out.
myself because the book consolidates, as books do, a bunch of information from other sources. Like I think I have 563 footnotes in the book, including those relating to what I talk about in a more concise way, and then cite to my book because I think I said it better than the other folks did.
Certainly, you cite to yourself, true?
Yes.
Congratulations.
No, that's not my own opinion. That's reflected from the information gathered for the book.
The book doesn't have your opinion in the book, sir?
It has some opinions of mine in the book. This is not what I would describe as an opinion.
Your book is not your opinion.
That's not what I said.
I'm asking.
The book has things reflected in it about generally accepted practices that I don't agree with, that are not my opinion. The book has things that do reflect my opinions or that align with my opinions, particularly the conclusion when my co-authors and I offer some specific suggestions. That's definitely opinion.
Sorry, Coco.
But for example, the chapter on constitutional law or state law, no, that's not my opinions. That's just what it is. That's about the state of the world.
Again, sir, redirecting you back to my question. I really appreciate that very long narrative that you just gave the members of the jury. But redirecting you back to my question, that footnote cites yourself. Yes or no?
It does. I'm sorry. I thought your question was, does my book have my opinions in it?
Thank you. I appreciate that. Turning to page 39 of your report, you claim that it is well known and is generally accepted in policing that officers should avoid putting themselves into a people's path of traffic.
Thank you for
You agree with
addressing
that,
this.
right?
Yes.
That's what you write it in your book, or I'm sorry, in your report, true?
Yes.
And you established you didn't take a poll on police to see if it was really generally accepted or well known, right?
Right, yeah, that's survey research is not how one develops that, but yes, that's correct. There is no survey research underlying that.
And in fact, there's no citation here at all. True?
Right, because that's an introductory sentence to the rest of the paragraph that has a bunch of cites in support of that particular point.
Sir, that's a whole entire sentence equipped with a capital letter and a period, right?
It is introducing a whole entire paragraph with a number of sentences on that topic.
And that sentence does not have a citation.
What are we doing here? What are we doing here? We don't belong here.
True or not true?
That sentence does not have a citation. Yes.
Now, that's an important statement. True?
The what's highlighted there?
Yes.
Sure. Like I spend multiple paragraphs on that point.
Okay. Now, you testified on direct examination about the IACP law enforcement policy, correct?
Yes, that's the International Association of Chiefs of Police model policy or consensus paper. I have a couple of different things from IACP that I cite in my report.
In those sentences, there
Read it every day.
one with no footnote cites the IACP model policy for vehicles. True?
One of them does, yes.
May I approach the witness, Your Honor? This is that model policy that you cite in your report, correct?
Yes, that's it.
May I have the Elmo, Miss Cook?
Elmo.
Now, on page 3 of that policy, this says right here, this document is not intended to be a national standard. True or not true?
Yeah, that's what it says.
That it's not meant to be a national standard.
Sure.
Now, you would agree with me, sir, that generally accepted police practices say that an officer can use force when there is an imminent threat to something that the officer is lawfully trying to do. Yes or no?
Sure.
May I have a moment? Thank you, Mr. Stoughton. I have no further questions for you at this time.
Oh,
Councilwoman Approach? Everybody, join the party.
oh.
Is everyone okay with redirect?
Thank you, Your Honor.
That's fair.
May I proceed, Your Honor?
Yes.
Quite frankly, I'm surprised they haven't started their 2-hour lunch yet. I'm quite shocked.
Professor Stone, you were asked about that sentence in your report. It is well known and generally accepted in policing that officers should avoid putting themselves into a vehicle's path of travel. Indeed, stepping into a path of travel of the subject's vehicle is perhaps the paradigmatic example of officer-created jeopardy, having been used as an illustration in. And then, right after the defense attorney cut it off, did you actually then go on to provide multiple citations?
Yes, there are 1, 2, 3, 4, 5, 6, 7, 8, 9. Yeah, I like that discussion goes on for the next page and a half.
So, right after you say it's perhaps the paradigmatic example of officer-created jeopardy, where does your report go from there?
It talks about that as an example of officer-created jeopardy. Again, just unjustified risk-taking being used as an example in books. I think that's a cite to the way that we use it in the book. Book chapters, training presentations. It talks about the International Association. Ooh, bad capitalization on my part.
Why are we talking about this?
Which states in relevant part, quote, "At no time should the officer or others stand in front of, between, or behind the stopped vehicles." It talks about these articles from 2005 in Police Magazine in 2006 that describe stepping in front of a vehicle or stepping into a vehicle's path of travel as a very poor tactic, placing the officer in a position where, if the driver attempts to escape, the officer may interpret it as an attack and shoot. The block quote at the bottom there, and that I think feeds over to the top of the next page, is actually from a 2025 article after the date of this incident, reflecting on the long-standing nature of this particular aspect of policing. In the block quote there, the author is reflecting on, "When I was an officer, it was unthinkable to step in front of the suspect's vehicle in order to order them to stop, excuse me. I do not know when this dangerous tactic began, but it is an ill-advised tactic. It is not an acceptable police procedure. This tactic is another example of officer-created jeopardy because it puts the officer in the zone of extreme danger." That's from a 2025 article in Police Magazine.
So did you actually cite fairly extensively after your assertion that it's well known and generally accepted that an officer should not place himself in front of the vehicle's path of travel?
Sure, that's how paragraphs work, right? You introduce the paragraph with a sentence that tells you what that paragraph's about. You then write some sentences that support what that paragraph's about with citations as appropriate.
And now there's been lots of talk about this officer-created jeopardy. Is there a preoccupation with just the specific terms officer-created jeopardy, those words?
Yeah, there seems to be a lot of focus on the magic words officer-created jeopardy, which are utterly irrelevant, right? Again, it's the concept of unjustified risk-taking.
Then why are we talking about
in the same way that when some police agencies refer to the backdrop of a shooting and other police agencies refer to the backstop of a shooting, it's not the disagreement in terminology that's relevant. It's the concept that both of those terms are being used to address. So whether we talk about unsound tactics or we're even more verbose and say unsound tactics that foreseeably increase the likelihood that officers will be exposed to danger that sound tactics would have avoided and thus have to use force, or whether we just summarize that as unjustified risk-taking or officer-created jeopardy, shouldn't really matter.
And if not the words officer-created jeopardy, are there tactics and concepts throughout the basic training curriculum of peace officers that deal with officer-created jeopardy?
Sure, if we didn't care about unjustified risk-taking, we wouldn't have tactical training at all. Right? We wouldn't tell officers this is the safest way to address a particular situation, or this is a reasonable scope of safe options to address a particular situation, because we wouldn't care about whether the risks they take are appropriate. But we do. That's why we have tactics.
And I know that it's not your job to instruct the jurors on the law that they are to apply, but it was asked about, had you received jury instructions from a defense attorney, and you see anywhere the words officer-created jeopardy? Did you see, while those words might not be there, would the words totality of the circumstances be there?
I would have to look back specifically at them. I think so, but I would have to look back specifically at what they were.
And if they did include the words totality of the circumstances, would that include the decision-making and the actions of the officer earlier in the encounter leading up to the shooting?
I mean, I think that's part of what it means to be totality of the circumstances instead of taking a moment of the threat or a final frame approach.
And now, Professor Stoughton, do you, in your role as an academic, well, I guess they've asked about 5.5 years as a police officer. You were a police officer.
Is the prosecutor dying? Is anyone else catching on to this? Anyone have any albuterol they can throw him? Jeez Louise.
Officer for 5.5 years, correct?
Yeah, thereabouts, yes.
And have you devoted your academic career to primarily the study of policing?
Yes, exclusively the study of policing. I've been a policing scholar now for 13 years. And that's really the only thing I research is policing.
He has been a whiny little bitch all those years. That is his professional CV. He just likes to live under this false concept that communities should police themselves, and that, well, no, he'd probably get pissed off at the community for that too. I don't know. Let's continue.
And are you still active in the actual world of police beyond that?
Please,
very much
no.
so.
Oh,
I
God,
run a program
no.
that provides police training
Ah!
at the officer level and at the executive level around South Carolina and around the country. I actively speak to police audiences all the time. I work with agencies all the time. So yes, I try to take myself out of the ivory tower to the extent that I can.
Oh,
And in your role as a scholar,
Okay.
academic, will you discuss or publish on ideas for what you think would be better officer practices, or even practices that are considered acceptable that you don't agree with?
Sure. Yeah. I'm part of my work as an academic is to identify promising best practices, to identify whether there's empirical research supporting that or not. The National Institutes of Science commissioned me and several co-authors to write a paper on the empirical evidence that we have about use of force, right? That is what affects officer use of force.
Congratulations.
So yes, as an academic working in the area, I certainly look for and attempt to promote best practices. But there's a significant difference between my role as an academic and my role as an expert, and the promotion of best practices or cutting edge practices and looking at generally accepted practices, which are
Something
really
smells
beyond
hot.
reasonable dispute.
And
Might be my hair.
do you keep those roles distinct when you're asked to review a case to provide expert analysis as to whether an officer's actions were reasonable in terms of generally accepted practices and principles?
Extremely distinct. The way that I sort of analogize it is like the rules for my kids at my house as opposed to my mom's house. They're both rules, but they're different rules, right? So depending on where we are, different rules are going to apply, and they should, because my role as an academic and as someone working in this area is very different than my role as an expert witness. In the same way that like an attorney can argue two different positions in two different cases, right? It's just a different professional obligation.
And have there been times when in your role as an expert, you've reached the opinion that
This is so offside across.
this is, have there been times in your role as an expert where you have found, you reach the opinion that the officer acted reasonably consistent with generally accepted principles and practices, even though you didn't necessarily agree with that principle or practice being generally accepted?
Yes, there are situations where I think there might be better promising practices, but that's not my role as an expert to assess better promising practices, right? My role as an expert to say at the time what was generally accepted, and that's the answer. It either is or was not.
So when you're retained as an expert, is it to not analyze whether or not an officer was using the best practices or whether or not the actions were reasonable?
I'm sorry, ask that again.
When retained as an expert, is your role to analyze whether or not the officer performed the best practices or just whether or not those practices were reasonable?
Yeah, as an expert, I do not assess whether the officer acted consistently with best practices. It's just whether they were reasonable, professionally appropriate under generally accepted practices.
And have there been cases where you've been retained where you did find that an officer acted appropriately consistent with accepted principles and practices?
Yes, yes, there have been.
Have there been numerous times?
There have been numerous times. Some of them don't go to trial. Some of them, especially retentions by a prosecuting office, I issue a report or testify in grand jury, and there is no criminal trial because there is no indictment or prosecution, right? Or in cases that do go to trial, there are typically split opinions where not everything an officer does is inappropriate. There are things that might be entirely appropriate in the scope of the actions that I'm reviewing. So that's part of the overall opinion too, even if what tends to get focused on in litigation is the specific things that officers may have done wrong.
And Professor Stoughton, it's been talked about how you weren't a police officer in Ohio and you're not an Ohio guy. Does
Thank
that have
God.
any relevance to determining the generally accepted police practices and procedures?
No.
Would that vary state to state?
In the context of this case, no. Cars run over people in South Carolina and Ohio.
And you were shown during cross-examination a quote or a head note from State v. White when it talked about experts not engaging in armchair reflection and about what an officer could have, should have done. Is it also generally accepted in policing when evaluating the use of force not to use that type of armchair reflection?
Yes, absolutely.
Does that mean there can be no consideration about what an officer should have done?
No. So there are two different reasons that policing might review an officer's actions, one of which is to see whether the officer or any other police employee did something wrong. Separate and apart, we might look for whether there are things that the agency as a whole might do better, whether there are changes to training or policy or equipment that might improve future outcomes. The way that I understand White and the general prohibition on the sort of armchair quarterbacking is don't confuse those two things, right? Just because there could be something that was better that would have led to a better outcome, that does not necessarily mean that an officer did something wrong. Sometimes an officer does something wrong, and if they hadn't done that thing wrong, it probably would have led to a better outcome, but the focus is on whether they did something wrong, not the sort of alternatives.
And in this case, what did the defendant in fact do?
He stepped in front of a car. He stayed there for a total of about 10 seconds. When the driver of the car turned the wheel, he drew his gun and remained in front of the car for more than another 4 seconds. As the car started to move, he continued to remain in front of the car for another 2 seconds, and he ultimately shot and killed the driver.
And were those actions consistent with generally accepted police practices?
No.
May I have a moment, Your Honor? Nothing further. Thank you, Your Honor.
Any questions as a result of this?
None necessary, Your Honor. Thank you.
All right, you can step down.
Thank you.
All right, ladies and gentlemen.
What are you doing? Thank you, maybe. Angry Beard, I don't know what you're talking about. You said, Lacey, am I deaf? Well, I certainly hope so. Not, I also, real talk, guys, it probably wasn't the best idea to eat a plate of orzo 45 minutes ago, cheesy orzo. My husband makes it for me when I'm hungry and I want something hot. Because it's easy. And it was sitting on the stovetop. It was left out last night. And that's not the problem. It's the problem that I just ate a bunch of carbs and now I caught most of what was asked. But now we don't know when they're coming back from break. What are we doing here? What are we doing? All right, so I guess I'm going to have to go and go on the news website. Let me see. because they're doing live updates. Okay, 2 minutes ago. Let me share this tab instead. A law professor. No. I don't understand this cameraman. Oh. So, breaking news. Don't even know if that made sense. Is there a Sure. Okay, cool. So I received a message last night, and I've been trying to I've been trying to find the paperwork to confirm that this is the case. No pun intended. But I was told, one second. I promise it'll be worth it. I am not seeing his everything's just so difficult. Connor Grubb charges. Because I always get that one wrong. You know what I'm talking about? Know what I'm saying? You know what I'm saying? Man, look at this. Just read that. Okay. Connor Grubb charges. I know it's murder. I know it's felonious assault. And for the fucking life of me, I'm sorry. This is a cursey stream. I always mess up the other one. Okay. Involuntary manslaughter. Okay. So I was told last night by an anonymous source very, very close to the situation, to the case. Let's leave it there. That, as you may have known, Connor was being charged with 2 counts of murder, 2 counts of felonious assault, and 2 counts of, I already forgot what it was, involuntary manslaughter. The reason for that was because she was pregnant. And I was told that those counts that were meant for the baby, the fetus, were dropped last night. It would appear as though the judge used the very, very long day of as you may know, this is why I shouldn't eat, guys. This is why I shouldn't eat, because I'm just like, I'm not making sense. Okay. I am not going to look at comments. I am going to focus on what I'm doing. So, 2 counts for each of those charges. One of those counts on each of those charges. So, the involuntary manslaughter, the felonious assault, and the murder that were directed towards the fetus have been removed. That is what I've been told. I have been on, share this tab instead, on the docket this morning, and I see that there was a motion filed yesterday, but it's about Kevin Davis, and I don't think that Kevin Davis was a part of this. But that, I believe, explains why he finished up court at 11:30 yesterday. By the way, I literally did not know what to do with myself. I'll tell you what ended up happening. I was starving for an unknown reason. I don't know why I've been so hungry early recently, because I don't normally eat this early. I usually eat like one meal a day, and it's dinner. And I decided to make myself an individual sized portion, like the little box of Stouffer's lasagna. You guys, I have a 20-pound French bulldog. I would say that's about the amount of food that I give her in an entire day. So like morning and night. And it took 40 minutes for it to cook. So by the time it was finished, I can take this off. By the time it was finished, I was like hangry. It probably actually had something to do with me getting my blood drawn yesterday. Which, by the way, I just looked at the results when I was in the kitchen. All of my my triglycerides, my cholesterol, all that stuff is great. It's just the other thing that I'm dealing with that I'm that's the only medical malady right now, but everything, like normal tests, they all look good. So with that being said, I can't confirm the information about the fetus's charges being dropped. I can just tell you that the source that I have is very reliable, and I would be absolutely shocked if this source was not correct. I wasn't looking at the comments, and yeah, you know what, Frenchman? That's what I'm just gonna call you, Frenchman. I thought of you when I got that text last night at 9:45. I was like, holy shit, the French guy, he wasn't necessarily wrong. I think that they spent yesterday reviewing case law, video footage, and it all came down to the realization that the officers didn't know she was pregnant. Nobody knew she was pregnant, apparently, except for her grandmother, who had a restraining order against her. So the grandmother had a restraining order against her, which she had violated, and there was a warrant out for her arrest. We're talking about Takaya right now. And so I'm not quite sure how the grandmother knew. Maybe it was like a CPS thing. Like Child Protective Services was like, hey, we know that you're in charge of her. You're the guardian of her 2 children right now. We wanted to give you a heads up, like she's pregnant. Maybe that. Let me see what you guys are saying. Yes, we will find out with jury instructions. I mean, don't hold back, French man. Jesus. I can't be all the things you guys want me to be, okay? Okay. We will find out with jury instructions. The other thing that was said, which I have not necessarily responded to, but because I don't think this is the case, I think this is wishful thinking. I was told that there is a high possibility that there could be closing statements today. I find that hard to believe. I don't know if that's the I mean, you guys agree with me, right? Like, if you guys have watched previous trials before, usually closing statements are done back to back so that the jury doesn't sit on one closing statement overnight and so on and so forth. So I was also told that depending on how Stoughton did today, the defense might have another witness on standby, depending on how he did. So I took my Adderall, right? Yeah. I actually think I even took it on camera. Yeah, it also, I don't know what you mean, maybe. That's what I'm trying to get at. I need you to be more specific, please. John is not wrong about that either. Let's see if there's any updates from Channel 4. What? There has been an update since then. Oh, okay, here we go. Here we go now. Here we go. Here we go now. I hate that my lap. I can't talk. I'm struggling. Blame the old guys. Blame the old guys. I go out with the old guys on Mondays, and Tuesdays are always a little slow to get into the groove of things. I don't know about you. I'm feeling 22, but I kind of feel like the judge is going to come back at 1:30 and be like, okay, well, that's it for the day. So see you tomorrow for closing statements. I kind of feel like that's going to be the case. So my thoughts maybe is that taking away those charges, I hear what you're saying, but I don't think it was I think it was more, this is my completely personal opinion. I am not, this is not reflective of anyone else or any other groups. I think this was very much a racial issue, and the pregnancy was not as important, but my opinion has wavered on that over time. Like at the beginning of the trial, that's why I thought we were here. But I've kind of lost that thought, that opinion as we've gone through this. And I don't think it's a matter of like less sympathy, because I think it's okay for the jury to recognize that it was a horrible situation, but at the same time, it was an entirely preventable situation on behalf of Takaya. If you guys want to call me an awful person for saying that, whatever. I used to work in politics. I have been called far worse. There's not another way to say it. I think the city of Columbus, it was like they were trying to create their own George Floyd situation here. And I do not personally know one person that feels differently than I do about this case. The only person that I know who I actually like, who differs in opinion, and I don't know if his difference in opinion would lead to a different like outcome in a judgment, is Anthony, my dude that comes in here in chats. I love Anthony. I've never met Anthony. I know him from Turtle Boys chat. And we've become buds just in the chats. So if you see Anthony, say hello. He told me at the beginning of the case that he had met Takaya, which is crazy to me. They ran into each other at a crime scene that was taking place. And he holds the position. I don't want to speak entirely for him, but he just thinks that Connor shouldn't have been in front of the car. And that seems to be what the prosecution is hoping to hone in on. Yeah. No, the pregnancy was 6 months. The autopsy, excuse me, the coroner said, which maybe and I were like, the coroner said that the baby could have lived, but he would have needed grave, like, medical attention. Yeah, no shit. Like, the lungs aren't fully developed, not by a long shot. What, not where? What are you referring to? And what else? I think that's, did I finish my thoughts on that? Oh. Stop sharing. Let's stop sharing for now. Stop sharing. And let's go to YouTube. Do they have? Sorry, guys, I'm trying to see if there's anything else I need to include. Let's plan on. Okay. So we're on a break right now for lunch. I would like to go and watch the news that is on right now to see if the people inside of the courtroom have any information as to what comes next, if we're going to hear closing statements. So Sebastian or Frenchman, in this case, it wasn't the shooting, it was her trying to plow down the police officer. And obviously he couldn't use a taser because a taser would not have gone through the windshield of the vehicle. So he had to neutralize the threat. It's a very cold way of breaking down this situation. Okay. So let's reconvene at 1:30 Eastern. So that is in like 45 minutes. And yeah, that's right. I'm going to drink some caffeine and try to get a grip because your girl is struggling. I'm telling you, it's that whole like day yesterday and that really threw me for a loop by not having court for the majority of the day. So I'm going to put Words on Stream up and I will make sure that I am back here before court starts at 1:30 and Sebastian, you're just going to have to go back and watch. She was trying to run him over. He was in front of the car. There was no time for alternative methods and trying. There was already attempts made to de-escalate the situation. So he actually got injured from this situation and his life was in danger. And he has the absolute need to protect himself as well as others. Who is Lazy Jane? I don't know. Who is she? Okay, I'm going to put on Words on Stream. And I will be back in 45 minutes. I hope to see you guys then. But until then, please make sure to like the stream, comment, chat amongst yourselves, and did I say subscribe? Yeah, I need to take a break. Okay, I'll be back soon. Oh, sorry, guys. I don't have the camera on because I wanted to put on deodorant, and right when I hit the speaker button, my very professional bag of makeup just tried to fall on the ground. So, all right. Now that we are all set there, let's get it started. Ha. Let's get it. Oh no. Oh crap. Hopefully I don't get in trouble for that. We shall see. There's just a sentence. Don't be weird. I feel much better. I just went upstairs and laid next to Pearl. She's kind of been like how do I put it? I don't think she's sick. I don't know. She's been very like bleh recently, like the last 3 days. But she's eating and drinking, so I haven't like dropped everything to take her to the vet yet. I don't think we're there. But let me not make small talk right this moment. As you may have seen on my X, I got an alert alluding to what I had said in the stream about an hour ago, which is that the charges were dropped relating to the fetus in this case. I'm stressed. So Pearl is stressed. You know what? Maybe this is actually judge me all you want, you guys, but this is like the most I haven't been this filled with purpose in quite some time. So you guys have given me a lot of joy. I'm not happy about the case. Please don't get it twisted. I think it's horrible that we're even here. And my heart goes out to both of these families involved. I just feel like I've been praying for a long time for God to, redirect my purpose and show me where I need to be and what I need to be doing. And I recognize that this has been far from an outstanding job on my part, but I also understand I'm new to this. So there are going to be bumps along the way. And all I can do is give it my best and just take note of things that aren't working and just work from there. I gave you joy. I demand a refund. I want to speak with your manager. I'm Riley. I'm kidding. Oh, God. See what you did. See what you did. My deaf 14-year-old dog, he only hears like in really high decibels. And like, yeah, he overheard that. Yes, there is a learning curve. At least I'm on it, and that's the thing. If people want to come in here and say, oh my God, she's so bad, I really think that she is the worst interviewer and YouTube person I have ever seen. Oh, okay. Hey, what's your stream called? What day of the week is it and what time? Because I'd like to see you on there since you're so fucking fucking great. Sorry. Apologies to everyone wearing headphones. Speaking of which, if you could please like this stream, comment with your favorite emoji. If you could share it. I mean, that's a lot. That means so much to me if you could do that. Or if you feel like you can provide support monetarily, that is greatly appreciated. I cannot even begin to rattle off the items that need changing around here. Like, I'm sitting on a couch. So, well, didn't need to show you my seat, but this is definitely not the best, streaming setup, I guess you would say. Oh, and then this is my desk. It is a UNC Tar Heels, like, little one of these things, tables. And then this is a, like, what do they call these? Like, it's one of those tables that you, like, eat dinner at. Sorry, guys, I'm turning you all around. Couch, laugh my ass off. Crotch.com. Oh, crotch cam, not crotch.com. Yes, I didn't need to show you that. Thanks so much. Thank you so much. There's also memberships. I think that a lot of you are members. Please send me an emoji. I spent time on those, and I actually have a couple more that I need to upload. So if you are a member, please show off your member skills and post with one of the emojis for members only. Please and thank you. But thanks for the $5 for the very unfortunate position that I took with my camera. I appreciate you. And yeah, the more people that we can get it in here, the more eyes on it, the better. When I was upstairs laying with Pearl, I was trying to find more, like, officer involved shootings in relation to trials, officers that may be going on trial. And pardon me, thankfully, there are not many. Unfortunately, Ohio was mentioned several times. So, and it's not Ohio, it's Columbus. It's unbelievable. Oh yeah, and, like, this is just, I'm only giving you 2 examples of, like, a setup. I have these 2, like, janky desks, and then this like, little couch thing. I should probably get a chair because my back is killing me. A desk would be great. A second monitor would even be better. And let's just not even go over the headphone thing. That's a whole thing. A whole thing. Yeah. I need a lot of help, guys. A lot of help. Yeah, see, I don't have 2 monitors. And so I recognize that, some people are like, "Oh my God, it's such a grift." I'm trying to provide you guys with the best possible service by sharing these streams and providing you with insider information, like the information about the charges, which I almost didn't tell you because I didn't have a second corroborating source, but it was someone very close to this situation that I felt, okay, well, I can share this information. I do know that Connor did want to testify. I'm glad he's not. I'm glad he's not. That was also mentioned in the screenshot that I shared on X. Oh my God. Look at this. That was definitely 1:30. What a bunch of gypsies. See? See? Even this says 129. Oh, you guys can't see. Even this says 129 down there. Your browser has lost connection to the screen share audio. Try sharing your screen again. Restart your browser if this continues to be a problem. Well, that browser doesn't have any audio going. So whatever you say, StreamYard. Okay. Normally you want the defendant to testify in a self-defense trial, but his statement was read into evidence and the videos speak for themselves. Exactly. I really, and based off of what I know about Connor, he is just like a super easygoing guy. And I feel like the prosecution would put words in his mouth, and I just don't, it's not one of those situations where I'm in love with it. So I'm happy that he's not testifying because I think that we have enough as it is. I think we are in a very good position, which if you guys weren't watching this morning, I shared some pretty crazy information that I found out, which is that Connor was really urged up until the week of the trial to take a plea. And that bothers me. It bothers me that that there was this. Hold on. I think I hear my alarm going off. No, I'm just crazy. So it bothers me that he could have just been like, okay, well, I'm going to go to prison for X amount of years and admit guilt for something that I am absolutely not guilty for and I should not even be on trial for. It just doesn't sit right with me. And it's not like there's any information that you guys don't know about that is the reason for that. I think it's simply because there were 2 charges for each of, the homicide, the assault, and the murder. It was times 2 on all of those because she was pregnant. So it wasn't just like 1 life sentence, it was 2 life sentences. I think that was now that I'm moving like this, I don't want to stop. I think that was the thought behind it. And yeah, I don't care. It still bothers me. Now, I see that maybe posted or like typed in the chat my emojis, but I can't see them. Yeah. John's comment, I 100% agree. I'll show you guys what he just said. Okay. I could see him taking a plea for no jail time, as you never know what a jury will do. But he shouldn't have taken a plea with prison time. There's just no way. No way. It's nonsensical. You know what I'm saying? Know what I'm saying? So, thankfully, we let this play out. I say we, like I'm involved. And I don't, there's just like, there's no way. There's no way. There's no way. Let's see where you guys are in the poll. So 12% have said that the state has proven the guilt of Connor Grubb. That's interesting. 88% say that they haven't. Did they switch the time? No. Huh. Well, that's weird. So do we believe Channel 10 or do we believe Channel 4? I'm checking Channel 10's website right now. Oh, look at this. The very first thing on Channel 10's website, Jason Mead's trial. And trial begins for Blendon Township, Connor Grubb. All right, so here we go. There's Lacey. Let's let her do her thing. That was yesterday. Okay, well, they are, this was updated at 1 o'clock. A judge on Tuesday dismissed 4 charges against Blendon Township officer. Connor Grubb, who's accused of murder in the deaths of Takaya Young and her unborn child. Young was fatally shot by Grubb inside a vehicle in the Kroger parking lot on Sunbury Road on August 24, 2023. Judge David Young announced that in court that 2 counts of murder and 2 counts of felonious assault will be dropped. According to the indictment, those charges were related to the death of Young's unborn child. Young explained there was no evidence of Grubb knowing that Young on the day she was fatally shot. The state and defense attorneys are expected to rest their cases Thursday afternoon when the jury returns from lunch. Grubb is also not expected to testify. Okay, first of all, I think they mean Tuesday. For real? Okay. I'm going to check this channel one more time. So where are we with closing arguments then? This is what I hate about not being there. Oh my God. There has been a flight added with nonstop to Key West. Hell yeah. Sorry, guys. This is what I don't like about not being in there. But I recognize that if I was in there, I would not be able to do this. And so on this website, it's not giving me the opportunity to share. Hold on. Okay. So all right. So Grubb now faces 2 counts of murder. I'm reading this wrong, right? Or they wrote this wrong, correct? He dismissed 2 counts of felonious assault and 2 counts of murder in relation to the death of Takaya Young's unborn baby. Grubb now faces 2 counts of murder, 2 counts of felonious assault, and 2 counts of involuntary manslaughter, all in relation to the death of Takaya Young. Yeah, there's a disconnect. I guess we're just going to have to wait until He reads jury instructions. I don't know. This is just dumb. This is dumb. I'm trying to see if there's like any reporting that I can show you guys. $143 is when it was updated. So apparently, Connor originally faced 10 counts and now faces 6 after Judge David Young dismissed the 4 relating to the unborn child. I keep trying to make it make sense, and it's not making sense. All right. Yeah, jury instructions will clear it up. They're still completely not correct in their time. Hi, if you guys are brand new into watching this, please make sure to like the stream. If you could share it, that'd be magnificent. Or if you just want to leave a comment, subscribe to my channel. Duh, why not? It's free. And I'm a hoot. So there's that. It would be great to have you guys along. And I am just now getting like the memberships. I'm going to start doing, I'm going to add like the Discord information. I need a mod though that I can like have share that information. Because this Discord is really not my thing, but it's used by a lot of other creators, and I struggle to say that I'm a creator as this is my first stab at this, but I intend on doing a whole lot more, including Jason Mead's trial, which will be in January here in Columbus. Best time of the year to visit. Sorry, guys. I'm trying to make sure I have. Okay. So I guess that if we're waiting until 2:30, I wonder if that means that we are going to do closing statements. And once again, I was right about the 2-hour lunch. This is stupid. Pardon me. See, the thing is, maybe I want to send that to you, but I don't want to send it to everyone. And so I'm stuck unless you want to do the the StreamYard thing, and I don't. I'll make sure to send you the Discord invite. I just need to figure out, like, you know how you're in other chats, for example, Nightbot. I hate that thing, but I can understand his usefulness since I've been doing this. So, like, when does Nightbot become an option for content creators? When is it possible for, like, a mod, and maybe you do know this, maybe, but, like, when does a mod get the ability to, like, type in exclamation point donation exclamation point, and then something in the chat shows up about donations? Because I've done it for other creators. I don't know if that's like 1,000 subs, if that's available to me now. I don't know these things. There's something going on. Okay, it says breaking news. 10 weather impact show. Let's see what's okay. Oh, you guys can't see. I'm just share this tab and
And what we'll have to watch for here tonight, because of all the rain, the ground is saturated. And as we get some colder air and drier air building in over top of that, it is possible that areas near and south of I-70 could see some fog developing and potential for some dense fog that would reduce visibility down to under a half a mile. So that's what we're watching here going into tomorrow morning. Now, not a guarantee. We're not talking about widespread fog, as there may actually be some clear skies to the north, but we'll have to watch that here through tonight. So just keep that in mind. If you're heading out in the morning on your Wednesday, you might encounter some fog. And if you do, just be cautious, take it slow, and just make sure to keep your low beams on here as we go into the morning hours of Wednesday. Now, if that does develop, that'll clear out of here, and
oh my
we'll actually
gosh.
see some sunshine going towards the midday.
Sorry, I just choked a little bit. So we are having a breaking news impact weather stream because it's about to rain. Why are we here? Yes, and maybe that's what I'm referring to. Like, it's something on my end that I need to be able to, like, type, hey, if a mod types XYZ into the chat, you are going to, you being YouTube, you are going to put the solution to whatever equation I can't YouTube talk. I need someone that like understands the jibber jabber of someone new to this. We already examined your zipper. Okay. That scared me. That was wrong of you. Yes, like that. I've seen it on other creators' channels where a mod does that, and then like Nightbot comes in and says like, if you want to donate to this creator, this is their Venmo, like stuff like that. Okay. Now that we're all on the same page, I had an idea of something to show you. Sunbury Plaza. Sunbury Road. Okay. I need to use some Flonase. Share this tab instead. So this is, okay, not all of this. Holy smoke. Okay, focus, Lacey. This is right across from that Kroger's. Well, not right across from it, but the bar that I was at is on the other side of this tree line when this happened. This this is the area we have been discussing. Right before I clicked on that, I saw, oh, this. This was 2018. I'm assuming this is the same date. So this is just a different perspective of what it looks like over there. Because I didn't. All right, one thing at a time. I'm going to use my allergy medicine. It's almost 3 o'clock. That's why. I told you guys. I said not pills, Flonase. Sorry, guys. Yeah, so like I need to figure out how to use those functions. And I'm sure that Baker would be more than happy to help me out. The time change is what kills us because he's doing streams often during the day, and he's usually like good to talk and help and be all he can be, I don't know, when I'm going to bed. You know what I'm saying? So our schedules are a little bit off, but I'm supposed to talk to expert here. So maybe I will, but he doesn't use it. Recovery Addict does a fantastic job with this. And I think if you are going to have a stream where you do not have another human talking at the same time, it's just one person, right? It's so important to know how to utilize those resources. because at any given point, there's so much going on. Like today, someone was chatting and I couldn't stop looking at the screen and I was losing my train of thought and I didn't want them to stop chatting. God damn, these hurt so bad. Sorry, I never say that. Gosh. And I still haven't gotten my paperwork from YouTube yet to fill out so that I can get paid whenever I'm supposed to get paid. And once I do, I'll be able to switch some things up in here, but yeah, I still haven't gotten that paperwork from YouTube yet. So Lefty says Lefty can help you. He doesn't do anything. That's funny. Lefty does a lot more than you do. Lefty is an avid supporter of this stream. And if I went to school with him, I'd vote for him for school president. So there's that. Take that. He said, I don't have chat commands. I would help, but I'm a caveman, basically. Not that you'd know, jerk. Oh my God, the language. I just don't like saying that about Jesus. This is why I can't focus. This is why I can't focus. I'm not mad. This is a me problem. This is a no one else problem. This is a me having a very honest and transparent conversation with my medical provider. Do you actually go to Topgolf? Because I do, and my Topgolf has heaters, and they are quite nice. Yeah, I've seen Zach in other streams. Wow. Wow. Did you know that I'm certified by the National Weather Service to be a trained storm chase spotter? I quickly corrected myself because I naturally consider myself a storm chaser. But yeah, I am a storm spotter. Sorry, I was checking to see if we had any links or any streams going. Zach, thank you so much for the $4.99. Thank you so much. For that dad joke. Yep. That was fantastic. Now I need to share this tab instead. Do you guys think that we're going to get closing statements? Arguments? It's 2:15. So I guess it's all contingent upon how long the judge is giving the prosecution and the defense to make their arguments. Usually the longer the case, the longer the statement or argument, whatever you want to call it. So what, we're at a week and a half. Yeah, there's maybe they Top Golf, but he said it's like an hour away from him. They have heaters, so it's pretty nice, but I wouldn't drive an hour either. I don't blame you. What else do we want to look at? There were no updates to the oh, dear Lord, if you could please help me with my alliteration skills, it'd be so great, Lord. Because I'm getting to the point I want to punch my own self in my own face. In your name, amen. There we go. It's going to be better now. Maybe I'll stream after work tonight. Oh. All right. So, can you see this? Okay, we're all on the same page. Just making sure. Bet you guys didn't think you were going to see me pray on stream. No. All right. So, I guess I don't understand, which will be explained to us, I know. But why the 4 charges of murder? And also, why was her sister never served? Excuse me. Jury instructions. All right. Hello? Can this like go over? No. Okay. Okay. The defendant maintains that his use of deadly force against Takaya Young and her unborn child was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified because he feared for the actions of TY would cause death or serious physical harm to the defendant. To establish the defense of jurisdiction, the defendant must prove that he was justified in using deadly force by the preponderance of evidence. There we go. What is the preponderance of evidence? Let me tell you. Preponderance of evidence is the greater weight of the evidence that is evidence that you believe because in your mind it outweighs or overbalances the evidence opposed to it. A preponderance means that the evidence is more probable, more persuasive, or of greater probative value. It is, sorry guys, I don't have my glasses on. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proved by the preponderance of evidence, you should consider all of the evidence bearing upon that issue, regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of an issue has the preponderance, then the defendant has not established such defense. If the defendant fails to establish the defense of jurisdiction, the state still must prove to you beyond a reasonable doubt that all elements of the crimes charged Sorry, I'm going back through comments. Is 67 degrees too cold in a home? Because my fingers feel frozen. But I also don't want it to be like so hot that I just drift off and sleep all the time. You know what I'm saying? I feel like I do this towards the end of every stream with you guys. Just throw over my bitty shaw. 67 degrees, not 60. It's always like this right before 3 o'clock. Always. All right. So John said that he usually keeps his house around 62 degrees. And this year he's been doing 65. Yeah, that's a little too cold for me. I was more or less thinking like bumping up 2 degrees. Yes, to 69 degrees. I know, it's hilarious. All right, where were we at? Oh. And it also goes over use of force. Gosh, this is like, all right. Reasonableness. The reasonableness the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather that with the 2020 vision of hindsight. The determination of reasonableness must allow for the fact that the police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. That just seems like a run-on sentence. I'm just saying. Maybe I'm wrong. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's actions were objectively reasonable in light of all facts and circumstances confronting him without regard to his underlying intent or motivation. So that was submitted by the prosecution. Geez, Gary. That's actually a very good point, Patriotic. Why didn't we see the video from Kroger's? I get that it's difficult for me to say that. It definitely relates to why she was shot. But it's just dude, I don't do FaceTime. And I can't even get on it on this computer. I only do X. Yeah, it's not going to let me. So when I saw that you had messaged me back when, that was like a freak of nature situation. I was using my other laptop, which has me signed into X. Only factors that the officer knew at the time he used deadly force are supposed to be considered. Yeah, that makes sense. So, only factors that the officer knew at the time he used deadly force are supposed to be considered. It relates but does not weigh into the decision to do any of the actions. I think that is a good way to put it, because he used deadly force because the car was coming at him. The car was coming at him because she was evading police after shoplifting because of the warrant. We assume as much, at least. She didn't want to go to jail, or I don't even think she would have been given a summons. I think she would have gone to Franklin County for the night. And yeah, that's let me read what Maybe said. Oh my goodness. God bless you, Maybe. I can't even imagine. That's so intense. God bless you for taking care of the one you love. All right, it's 2:30. Okay. Okay, look at this. Damn it. Jalen Young. Attend and give testimony at a trial on the date, time, and location specified below. So that's something. I understand what you're saying, Maybe. She said Takaya's decision, how she reacted, has nothing to do with his charges. Huh? Oh my God, this judge. No, that's not Jalen. That's not my understanding. No, you might be right. How dumb would that be if there were 3 parties involved in this lawsuit named Young? You really got me thinking, Patriotic. Why is you pulled up a document we couldn't see? Oh, it just said that that Jalen Young was supposed to, she was being subpoenaed to appear in court yesterday, and the subpoena was not delivered. She was not served. Yes, you are right. Because I remember seeing the unique way of spelling it. Shake the cobwebs loose. In what way? Oh my gosh, is this court ever going to start? What are they doing? This is just stupid. And why do I keep putting these on when I don't need to? I'm going to grab another Coke before this starts. I will be right back. If you guys only saw how I have to get back here, you'll you would be ashamed. I have to like high step over because there are a whole bunch of wires and cords and things. Oh my. Maybe they're talking about jury instructions again. Well, it would be my hope, most certainly, that they would videotape that. Like they would show that on this stream. Do you guys have any questions? I wish I could pull up my Facebook Messenger so I could read what was sent to me. I want to show you guys something that was just sent to me. My husband just said that this judge doesn't give a fuck. I could not agree more. He sent me a photo. I pressed the little button to download said folder or photo. All right, well, never mind. You guys aren't going to see the really funny photo. Okay, maybe I'll be able to show you now. Oh no, what did I do? I pressed that I wanted to not, my screen is all messed. Is there a YouTube school? Just wondering. Escape. Let's see if this works. Okay, this is better. Image file. Desktop. Why? All right, well, I guess it just doesn't want me to show you this hilarious photo. I don't know why. My computer does not have a sense of humor. I've never I hear what you're saying maybe, but it's not always been like this. Not by a long shot. It certainly wasn't for the other officer trial that didn't make it onto mainstream media, so I had to watch it through local. It's just frustrating. It's just frustrating because I want to stop. I want to show you guys all the things, and I can't. Do you need to stop sharing the trial to share the photo? Maybe that thought did go through my mind, but I'm not going to. He also sent it, and it's like image and then a bunch of numbers, dot HEIC. Like, I would think that oh my God, my back is killing me. Maybe that's why I can't show it, because what in the world is dot HEIC? Okay, so I was told there's something motions in lemonade. – 29th. I was not looking at that date. I was looking at 30th. Okay, got it. Thank you. And once again, it's tiny. Okay. At a hearing on September 17th, 2025, the defense asked Professor Stoughton if he had testified before the grand jury. The state objected to this question, but the court allowed the witness to answer over the objection. However, defendant was not entitled to that information, prohibits the disclosure of matters occurring before the grand jury. Thus, in state, blah, 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 the court held that grand jury subpoenas and witnesses witness identity were matters occurring before the grand jury, which are exempt from the disclosure under blah, 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 which also qualifies as an exemption from the disclosure under the Public Records Act, State versus Rutherford. I have yet another can. Have we started yet? I'm worried that I'm talking over someone. No, of course we haven't. What am I thinking? What would we have started? It is only supposed to start friggin' an hour and a lot of minutes ago. We're losing it over here. We're losing it. The wheels are coming off. All right. Let's continue. The release of grand jury material is governed by Colonel blah, 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 which provides in part that matters occurring before the grand jury may not be disclosed except when so directed by the court preliminary to or in connection with a judicial proceeding, or when permitted by the court at the request of the defendant upon a showing that grounds may exist for a motion to dismiss the indictment because of the matters occurring before the grand jury. Oh, this is the one that I want to see then. Hold on. Sorry. I want to see the information about the crime ring. Okay, here. Thank you, Patriotic. Damn, you were on it. Okay, now comes the defendant, Connor Grubb, by and through counsel who hereby requests that the court deny the state's motion in limine because although damaging to the state's case, the defendant knew this information, that the suspect was at the very least committing a theft from the store because the defendant knew of the theft crime ring that was operating in Blunden Township, and the evidence of the thefts corroborate all of the state's witnesses just provided on their 70-person witness list provided on October 28th, and every person who observed the suspect in Kroger. A memorandum in support is attached. Okay, hold on. Your girlfriend needs to take some Tylenol. Definitely taking the extra strength kind. I'm putting these on in case court does come back because I am absolutely concerned that it's just going to start and we're not going to hear it. Okay. Relevant evidence is defined as having any tendency to make the existence of any fact that is of consequence to the determination of the action or less what? Okay. The fact that the suspect stole 8 bottles of liquor from the Kroger with an additional 4 bottles in the car makes the fact that the defendant and the other responding officer had reasonable articulatable suspicion, which we talked about with one of the previous witnesses who testified, to investigate the suspect for, at the very least, theft, more probable than it would be without the evidence. The fact that the suspect stole 8 bottles of liquor from the Kroger with an additional 4 bottles in the car makes the fact that the defendant and the other responding officer had probable cause to arrest the suspect for, at the very least, theft. The fact that 8 bottles of liquor from the Kroger with an additional 4 bottles of liquor in the car were found in the defendant's vehicle after she fled from the store and ran down a police officer in a vehicle. Ran him down in a vehicle. They really did not hesitate to put that in there. Makes the fact that the defendant had to use deadly force to stop the threat of an aggravated robbery and felonious assault more probable than it would. I can't see now. I'm too far away. Than it would otherwise be without the evidence. The fact that every witness on the state's 70-person witness list in the state provided who saw the suspect in Kroger confirmed that the suspect stole bottles of liquor makes the fact that Connor Grubb was credible to BCI what he knew at the time he was trying to investigate the suspect when the suspect decided to run the officer down with her car. The defendant knew that the suspect stole items from Kroger. There will be Jesus, where are you? I was praying for your help. There will be testimony adduced at the trial that the eyewitnesses saw the suspect stealing liquor bottles. There were liquor bottles that the suspect stole, recovered in the Lexus that BCI eventually took possession of. This is all based on personal knowledge, and all were going through the defendant's mind at the time he was encountering the suspect, which, by the way, as much of this has been thought of by other people that I've consulted with on this case, close to the case. As the court knows, that pursuant to the Fourth Amendment law, the defendant needs reasonable articulatable suspicion to investigate a suspect for a crime and probable cause to seize the suspect for a crime. All these are all germane issues at trial. Okay. Fan-freaking-tastic. Let's put some emojis in the chat for patriotic. Always coming in clutch with the information. Why was she stealing so much booze? Was she planning on starting a lawsuit too? Gosh, actually, I came to this position to laugh, and now that I'm here, I'm very comfortable. Help me, baby, help me. Look at me, I look like a fat caterpillar. Okay. So now I look like I'm wearing a very fancy sweater. The wheels are coming off, friends. The wheels are coming off. Let's go. What is going on? How pissed would we be if, we were waiting all of this time and then the stream just stops and they're like, okay, bye, without any explanation? Because I feel like we might find out. And your girl might freak out. Why am I wearing these? Well, that's interesting. Look at this. It's granted it's juvenile court, but that was what Takaya was on. She was on a diversion program for stealing. Oh, and you absolutely saw this correctly, guys. You absolutely saw this correctly. This was last night. Downtown Columbus. Rush hour. Yep. Okay. Get out of here, ad. Nope, this hasn't been updated. Okay. WCMH. $251, 4 minutes ago. Oh my God. Oh my God. Oh my God. Oh my God. I might actually need that. I am not donating to this, to anything, to Judge Young's anything. I am very disappointed in him. Very disappointed. Channel 10 still has it going like it's gonna be streamed. Meanwhile, court has recessed for the day. Riley. All right. That was 40 minutes ago, and I have definitely checked this website since 40 minutes ago. Just saying. And it was what? 3 sentences? Yep. Took her 40 minutes, 30 minutes to write 3 sentences. Just want to point that out. Yeah, no booze with Tylenol. Well, I don't have booze. I have Coke. That was a funny comment. I do need to speak. Okay. All right. Comment of the week. Comment of the week. Comment of the week. I'm losing my mind over here. Help. Pearl. Help me, Pearl Bailey. Help me. Totally unrelated, you guys. I have, being the wife with foresight, to see exactly what was going to happen that happened this morning. I have told my husband so many times that he shouldn't squeeze the dogs. And by squeeze, I mean I love you so much. I love you so much. I just want to squeeze you. Like after they eating, they're finished eating because they're going to puke on them. Guess what happened today? Right before coming live. Just to all the men out there, don't not listen to your wives. You should absolutely listen to your wives because we have this weird, innate, instinctual gut feeling when things are about to happen. So this is interesting. Interesting you mentioned that, maybe, because last night I went to bingo and I those in the chat, please don't say where. I went to bingo and my friend who always goes was there. And no, I get that, maybe. We've gone later than this. I'm getting messages about what happened. So I don't want to read them off yet. I need to verify, but I understand what you're saying. So the guy that I sit next to at bingo, he informed me that he and his wife, he's a real estate agent, but his wife has a in-home daycare and has for 30 years. And they also have 2 golden retrievers. And at any given point, his wife can have up to 6 babies in her home. And this was a new baby. A new baby, but this child had brothers and sisters who also went to this in-home daycare, and great experience between the both of the families, right? So last night it was a bit difficult to follow the exact lead up of events. And I'm only sharing this because I know that he doesn't have my channel information. He's one of the people I haven't given it to. He said that mom came to pick up the baby and she was holding the baby and she went to pet the golden, and they have these rules about their golden retrievers about how to pet them. If you pet them anywhere beyond the back, like, it's not a good thing, right? And the dogs were in a different area, but the mom had the baby and went to like go touch the dog, and the dog bit the baby and the baby had to get 2 stitches. And of all, thank God it was like a family that they're familiar with, right? Like, that would have been awful. B of all, thank God it was like only 2 stitches. And I can keep going on and on. I'm not like, thank God it was a baby, not a toddler, because a baby won't remember this. And a toddler, that literally scar them, literally and figuratively. And the people who offer this service, he and his wife were immediately like, oh my gosh, this has never happened before. Here are all of the papers, like the proof of vaccinations, and that they, in our city, I don't know if it's like this in all cities, but I think it's the dumbest thing ever. And it's just capitalism at its finest, which I'm a capitalist, I get it, but I think this is like overreach. But we are supposed to license our dogs. Like we're supposed to go through the county auditor's office and say like how many dogs we have and like upload their vaccination records. And they thank God, probably because they have an in-home business, but they had that and they showed all the paperwork and sent it like digitally to them and was like, please send us all of your medical expenses. Do not hesitate to reach out to us if you have any questions. We are so very sorry. Blah, 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 blah. And I may have been ear hustling a little bit while he was sharing this part of the story. But I overheard him say that the mom responded with like, we are going to need some time to think about how we're going to handle this. And I looked at him and I was like, the woman with 3 dogs and a cat, right? I said, Frank and I love golden retrievers. And he so quickly said, we will get rid of the kids before we get rid of the golden retrievers. Same here. What were you referring to? Your love of golden retrievers? I one of the things I said before he had really explained all of it, I asked him what the hell he was doing with having golden retrievers by babies. I literally said that, and I was like, that was not very sensitive. I sounded like a really big bitch. And he's like, you don't understand. Like, the dogs love the babies. We think that the dog, and this, I can also see this being the case as someone, when I was a child, my parents bred golden retrievers. I could see the golden retriever thinking this baby doesn't belong to this person. And in an attempt to bite the mother got the kid. Oh, yeah. I definitely have my dogs licensed. Just to do our annual trip to the vet. For anyone who is interested in getting pets, please, PSA, PSA, PSA. Maybe I'll turn this into a clip. Let me take this off. I need help in more than one way. Okay. So, for anyone that is thinking about getting a pet, we have 3 dogs, all of which are under 20 pounds, and we have a cat. And she's like, I don't know. How much do cats weigh? Just the normal size cat. Once a year, on this dreadful day, I swear on my life, this is like my least favorite day of the entire year. It's usually in July or August. My husband and I, we clear the entire day and we load them all up in the car. We go to the vet, and one by one, they get all of their vaccinations because they go to the dog park, they go on walks. So they need and they go to the groomers. So they need the kennel cough one. I've experienced that before, and it's a different kind of hell I never want to go through. So we have to get them all that, everyone except for the cat. We have to do rabies every X amount of years, whatever that is. And maybe why don't you go ahead and guess how much we spent this year on our 3 dogs and 1 cat for their annual vaccinations. Keep in mind, the cat is vaccinated as an indoor cat, not outdoor. She goes outside, but she stays in our fence area, and it's fine. Watch me say something, and of course. Oh yeah. So I was raised around big dogs as well. But my mom had a schnauzer when I was like 6 months old named Muffy. And Muffy, unprovoked, I guess, bit me. And Muffy was given to my mom's best friend. And to this day, I swear to you guys, if that were Riley, because Riley's 14, he is my whole world. He is my baby, even though he's the one that's barking and deaf and very needy. I'd give the kid away first. Oh, well, not so. Maybe said 2,400. It was 1,800. And that's not including like the monthly things that they eat for like heartworm. And then I don't know why Frank insists on going through the vet for this, but because I know it's more expensive to go through the vet than as opposed to 1-800-PET-MEDS or chewy.com. Like, I am a huge proponent of outside websites if it's going to save you money and help make it more affordable to be a pet owner. I think we spend for that very reason, I think we spend close to $600. I don't know if that's right. Maybe 400 in the pet medications because he buys them in an annual supply. And I'm like, I don't know why you're doing this to yourself, man. Like, what? All you have to do is tell the doctor's office to fax 1-800-PET-MEDS or chewy.com a prescription, and they'll do it. It's fantastic. I don't know about you guys, but you dog owners out there, we switched over to the farmer's dog probably 2 years ago. And I don't think that my husband and I can say enough wonderful things about it. Ironically enough, someone, I really hope that I'm going to say it because tomorrow is closing arguments. Someone who I have met as an anonymous source through this trial, but I've actually met in person. That person is in the dog supply industry, more specifically treats and food. And he said that out of all of the natural food that you have to refrigerate and it's not full of filler food ingredients, he said that farmer's dog is the worst. And he said he'd let me know a couple different brands that I can get from Hollywood Feed because I refuse to go into pet stores. When Lacey goes into a pet store, she ends up with a $5,000 French Bulldog or a $4,000 teacup Yorkie. That's true. What? I've been to that one too, patriotic. I've how do I put this? That's not where we take our dogs. However, when I've had a dog emergency, I've taken my mom's dog there, who has since passed. She passed in June. But that's incredible to know. I'm actually, everybody smile. Get it? Because you guys can't see. Okay. I sent a screen. I'm sending a screenshot to my husband right now with that information. I know that you guys are like, what is she even talking about? But this is important stuff, guys. Come on. You are welcome. All caps. God, that looks so awful. Shout out to Patriotic for that wise piece of information, because I know that's a pet clinic that's nationwide. It's where when we used to breed golden retrievers, if we had issues with the if we had like a stillborn, if a puppy was caught in the birthing canal, you could always take him to VCA because they were equipped. What? Ma'am, I am writing this down so that I can write a very sternly worded letter to my local government. And you said northwest or north, you said western New York. That is so crazy. The only place that does something like that, and I'm sure Patriotic might be familiar with this, the only place that does something like that in Columbus, Ohio, you have to show that you are financially like unstable. That's not the right word, but you don't make a certain threshold of money. So when I was starting out in politics, I was able to get my my dogs all neutered or spayed for free. It's the most ridiculous waiting list, but it's absolutely worth it. And they are completely they work off of like donations, and people in the state of Ohio, they can choose to have a customized license plate with their logo on it, and that helps fund this organization as well. Offers free. I don't know where you live, but one of my friends on X, who I've become quite close with the last couple of years, that's not where she lives. She wants to run for office in New York, but it's the area of New York that's like close to Massachusetts. And I'm telling her that this is done. And she should include that. I write slow. Okay. I know that we're not talking about this. We're not talking about the trial right now, but I had to divert after the judge just suddenly decided that court was done for the day after we spent 2 hours waiting to come back from lunch. I think that's probably like the third time that's happened with this judge. So what did George Bush say? Fool me once, shame on you. Fool me twice, shame on you. Fool me 3 times, something dumb. But if you haven't seen this before, that is a George Bush garden gnome, and his little belt has the state of Texas. Oh my God, I'm all wrapped up. I collect George Bush stuff. Watch. Either a bunch of people are going to leave or stay. He's quite a divisive character. And how I got that was pretty epic last year. During the national championship game, because Ohio State is better than any other football team in America. My mom's best friend came over and said, "Hey, I went to this white elephant Christmas party, and someone gave me this garden gnome of George Bush, and I immediately knew who I was going to give it to." I have become that person. Good thing Zach wasn't in here. Oh, is Zach a liberal? That's funny. But that's the thing, like when you work in politics, at least the way that I did, because I always worked for bipartisan organizations or issues, things that everyone could agree on. Oh, okay. I have just as many, if not more, friends who are liberal than Republican. When I married my husband, he had never voted Republican in his life, which is something I said I would never do. I would never marry a Democrat. And then I realized that was dumb because many reasons, but that's not it's not something I spend my energy disliking people over. I think that everyone is entitled to think what they want to think and feel how they want to feel. Just leave me alone. Okay, guys. I kind of wanted, maybe, do you still have some time? Like, I wanted to show you guys something, but I'm wondering, maybe it's not the most appropriate. Appropriate isn't the right word. I wanted to show something, demonstrate my brush cleaning, because I've been asked about it. And I don't want to be like doing it alone. I don't want to be doing it, guys. I voted Democrat until I was like 28. Then I reached the age. Oh dear. Okay. I have a bunch of my old campaign stuff. around here. It's all kind of everywhere. Oh, I did buy these like 15 years ago. And if you guys know who Jess Machado is, hopefully she's not watching. This is one I'm thinking about sending these to her. They're elephants on wine cups. I just don't drink wine. But I was like, this is the perfect like Christmas gift for a Republican who's not a Republican who drinks but doesn't drink like every day. So, you know, it would be either a cute thing to put up in their office or so on and so forth. It was $9.99 at TJ Maxx. And this was like 2015 I bought these. All right. So, do you guys have any questions about the case that I can answer? I think we've gone through some really great motions. Huge shout out to Patriotic. Here, I'll just share this screen. Focus, Lacey. Okay. So he said, let's see what this is. I think this is one of the ones that we already went through. Maybe. Hold on. So if my memory is correct, we went over the motion from the defense regarding this issue, but this is a response from the prosecution regarding that motion. I'll read some of it out loud, but first I need to quiet read to make sure I'm not saying the same thing over again. Okay. And also seeing if this is even important. I mean, it's basically just saying that the defense disagrees with the prosecution disagrees with the defense's motion regarding the grand jury testimony and feels that the defense failed to meet its burden and that the motion that they submitted failed to make any showing of particularized need for grand jury testimony. Specifically, the defendant's attached exhibit, which is a small portion of a transcript, fails to establish any particularized claim. The defense claim that grand jury testimony should be released because a written report was ultimately issued with a date later than the indictment fails to establish any particularized need, as the defense has cited no authority to support a requirement that an expert report be issued prior to grand jury testimony. See, reading that out loud, I have no idea what I just read. I don't know if you guys are like me, but I have to read it in my head in order to absorb it. But reading that out loud, it just felt like the same thing. I was saying the same thing over and over and over and using a word I've never used before. Particularized. I didn't even know that was a word. I'm just being honest. I'm willing to admit my shortcomings, guys. Further, arguments over the use of the term officer created jeopardy, something that we heard today, or attacks on the words imminent or immediate, neglect to include Professor Stoughton's explanation during his testimony, and in his report that professional standards incorporate not only a standard set forth in Graham versus Connor, but also add substantially to that standard. It's 3:30. Further, any request to obtain grand jury transcripts for mere impeachment of a witness also do not rise to the level of particularized need. This argument could be made in every case and would allow the disclosure of virtually all grand jury testimony. And it gives us a bunch of case law. So finally, it is error for the trial court to review a grand jury transcript in camera to determine if any inconsistencies exist between testimony of a witness and at the grand jury, absent a showing of particularized need by the defendant. In conclusion, for all the above stated reasons, the defense has failed to meet its burden and therefore blah, 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 that the grand jury transcript should be denied. Okay. This was the same day. Okay. Let me go ahead. One more second. I'm trying to see if I can get away with just reading like the conclusion or if I should pick and choose other parts. I definitely didn't read this earlier. I am definitely showing that today. I just saw my checking account when the prosecution called out Kevin's typos in his report yesterday. Anderson was probably CPD officer Ricky Anderson. He is the officer that shot Donovan Lewis. I think Kevin is on his case also. Thank you for sharing that, Patriotic. All right. Let me 1 second. I'm trying to think this through. I am going to let Riley out, even though it's raining, as the news has so diligently informed us of. And for everyone that has asked me about the, and by everyone, I mean like 2 people, about the cleaning of the makeup brushes, I'll do that on like a members only stream. I'll be back. Give me 2 minutes. Hi, buddy. Hi, little white fluff. You're raising a whole bunch of hell over here today. I can't make it stop raining, buddy. Okay. Okay. I'm not gonna lie, patriotic. That was not the best look when that happened yesterday. I recognize that errors happen and like, yeah, but I was like, oh, I would have done the same thing if I was the prosecution, in other words. Okay, so let me share this tab instead. Okay, now comes the state of Ohio by and through the assistant prosecuting attorneys of Montgomery County, Ohio, blah, 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 blah. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. States in relevant part, all relevant evidence is admissible. Evidence which is not relevant is not admissible. In State versus White, the leading Ohio case on officer-involved use of force, the 6th district addressed the standard to be used when determining whether an officer's use of force was reasonable. The required perspective is that the reasonable officer on the scene, standing in the defendant officer's shoes, perceiving what he then perceived as acting within limits of his knowledge or information as it then existed. The 6th district goes on to state that facts learned or discovered later and actions taken afterward are irrelevant in this review, even if they were relevant for some other purpose. In the present case, there is evidence, including Kroger surveillance video, showing TY committing a theft inside the store before the fatal use of force incident occurred. This evidence should be inadmissible because of the time of the incident. Because at the time of the incident, defendant had no knowledge of any specific details to any threats or thefts committed by TY. Defendant was in the Kroger parking lot when TY walked out of the store. A Kroger employee followed TY out of the store and reported to Sergeant Eric Moynihan that TY had just stolen from the store. Sergeant Moynihan then knocked on the window of TY's car and told her to get out as it was reported that she had stolen something. At the time of the use of force incident, the entirety of the defendant's knowledge regarding any criminal offenses TY may have just committed was limited to overhearing Sergeant Moynihan refer to this general allegation of theft by the Kroger employee. Thus, any additional evidence related to the thefts which was discovered after the incident, such as what was specifically stolen, the manner in which it was stolen, and the actual video showing the theft, is entirely irrelevant to the jury's determination of whether the defendant's use of force was reasonable at the time he acted. Additionally, a jury view of TY's vehicle has been requested. The vehicle is currently at the Blendon Township Police Department. Recent photographs documenting the current state or condition of the vehicle disclosed. Right! Sorry, he's deaf, so I have to really yell. I'll try to mute next time. Recent photographs documenting the current condition or state of the vehicle disclosed to defense as discovery item 151 show that the vehicle contains items that were allegedly stolen in thefts that occurred prior to this incident. It's not allegedly, it's fact. The photographs given over in discovery show the items in question arranged on the back seat of the vehicle. The jury should not be able to view these items as defendant had no awareness of their existence at the time deadly force was used. And the items did not even come from the alleged theft that had just occurred at the Sunbury location where this incident took place. Ding, 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 ding. Ding, 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 ding. Woo, 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 woo. Read that sentence again. The jury should not be able to view these items as defendant had no awareness of their existence at the time deadly force was used. And the items did not even come from the alleged theft that had just occurred at the Sunbury location where this incident took place, meaning they are from the other incident earlier that day down the road in Westerville. Consequently, the state requests that this honorable court to issue a pretrial ruling precluding defendant from presenting evidence of TY's theft offenses beyond the limited information defendant possessed from overhearing Sergeant Moynihan address TY, because the jury's task is to assess the reasonableness of defendant's actions within the constraints of his knowledge at the time he used deadly force. Any such evidence would be misleading, prejudicial, and utterly irrelevant to the ultimate issue in the case. Damn. Okay. Let's look at one more of these. We've already read about okay, yeah, I just read that out loud. Well, what was in the... I wish that the what am I trying to say? Sharing tabs would just immediately go to the next link. Because I keep forgetting that you guys aren't seeing. Okay, motion granted. Let me... Okay. Once again, I am not afraid to admit what I know and what I don't know. So, motion to quash. A motion to quash is a request to the court to invalidate or stop a legal order, such as a subpoena or a legal process. I mean, I figured as much, but I'm hoping for some further information. It can be used in different contexts, like challenging the proper service of a subpoena, arguing that an order is improper or burdensome, or in a criminal case, to challenge an arrest and the evidence gathered from it. Filing a motion to quash is often necessary before responding to a lawsuit, as failing to do so can waive the right to challenge the issue later. 1 second. I need to shut the door. Oops. Okay. So, Jane Doe is the Kroger employee. And what I'm reading here is that she doesn't want her subpoena. I really need to get a lawyer on here to like confirm what I think this means. That's actually a really good idea. Because I have a friend who would love to do this. And he lives in Blendon Township. Okay. Would you guys enjoy that, to have like an actual attorney on here who can answer questions about specific motions that we can't figure out? Because I think that would be pretty interesting. He's funny too. All right, it's almost 4 o'clock. We've been live for 6.5 hours. All right, one more. Just one more. Oh, an order to seal. It's 3 pages. Let's look. All right. Wait, isn't this what we just, yeah, we just saw this. Don't worry, I haven't put anything up yet. I'm just trying to figure out. Oh, I just thought of something that I haven't. I think it would be fun as well. Yeah, maybe I figured, since I don't have the stream up, I could try to share that funny photo. It's not going to let me. Yeah, that makes sense. It's going to be more and more difficult for her to remain anonymous as her case evolves. As in Takaya's family suing her for running out of the Kroger's and informing the police that she was shoplifting and so on and so forth. I was just thinking to myself, I wonder if I could get my friend to do something tonight. But yeah, I don't think we should count on that. Oh, access denied. I was denied access. Wait, why? All right, so everything that I'm seeing right now, I'm here. I will show you guys this, my screen. Everything that I am clicking on right now is all a bunch of the same involving Jane Doe. Okay, this is new. So let me stop. Get out of here. Okay. Findings of fact and conclusions of law relating to defendant's motion in limine regarding witnesses Seth Stoughton and Jeremy Bauer. A hearing on this matter was held on September 30th, 2025. State witnesses Professor Seth Stoughton and Dr. Jeremy Bauer testified virtually. Seth Stoughton. I had that left blank because I couldn't remember his first name. The court rules that both witnesses may testify as experts in the jury trial scheduled to begin November 3rd, 2025. Pursuant to Ohio Evidence 702, the court finds their testimony relates to matters beyond the knowledge or experience possessed by lay persons, that they are qualified blah, 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 blah. Okay. As it pertains to conclusions of paragraphs 25 in his report, Dr. Bauer will not testify to the intentions of TY. Rather, Dr. Bauer will testify that the visual cues caught on video of a right turn signal in the turning of the steering wheel would indicate that the vehicle was about to turn right. Well, I mean, no shit, Sherlock. Do you guys see this? No. I have a mountain lion on my lap trying to bite me. Oh, I'm sorry, maybe. Okay. I said one more. That was one more. It was a whole bunch of nothing, but it was one more. So tomorrow, stop trying to bite me. It's not time to eat yet. So tomorrow, closing arguments, and the jury is expected to begin deliberations. That kind of made my stomach turn. Ugh. So that leads me to my request, one of two requests. My first request. If you know of any trials that are coming up in like the very near future that you think would be interesting to do live streams on, for me to rather, and perhaps they are not being covered by like Law and Crime or Court TV, but they need to be televised in some sort of capacity or streamed so that I can access it, whether it be through their website or through YouTube. I noticed that as well, patriotic. I did. I'm trying not to point that out. I thought that was a bunch of baloney. Let me finish my thought. If you guys hear of anything that you think would be of interest, even in the slightest bit, send it my way in the comments or hit me up on X so I can look into it and we'll go from there. Second thing, if you are here and you have not done so already, can you pretty please press the like button. If you are not already subscribed to this channel, it would mean a great deal to me if you did so. This case is important to me for a plethora of reasons. I'm concerned about the safety of my community, about our police officers being able to do their jobs, and the national implications of this case, not just statewide, the national implications. So it would mean a great deal to me if you hit the like button, if you subscribed, if you commented with an emoji even, because that will help pull more eyes based on the algorithm to this stream. And we can get some more people in here that are aware of this case and go from there and keep doing this. This is my first live stream of a trial, so there have been no shortage of screw ups on my part, but we're doing our best. We're going with the flow, right? With that being said, if you would like to support monetarily, there is information in that pink ticker down below of my Venmo as well as my Cash App. And there is an option to do super chats here on YouTube, as well as get a gift membership or a membership to the channel, in which you are able to support the channel and see special content that is meant solely for members only. Okay. With that being said, maybe not says, have you gotten any idea how the jury feels? I was told that the jury was only emotional one day, and that was watching the CPR video. I was told that otherwise, I hate to say this out loud, but I asked the same question. I've been told that they look bored. So take from that what you will, but I mean, there are several possibilities of what that means. I'm going to try my best not to read too far into that. So, otherwise, tomorrow could be our last day, y'all. There's a there's a very good likelihood that tomorrow may be the end of this case. And I would ask that, in addition to my request earlier, that you please keep families in your prayers. This is this is not easy to watch, let alone I can't even imagine how the families feel and Connor. So just help these people, help the jurors, and let them be able to sift through the facts and focus on facts over emotion. And hopefully we will end the stream tomorrow. Either way, it's what was meant to be, right? So I can't say one way or the other, but all I can say is I hope that I know this. I've watched half of it already. All I can say is that I hope the families, whatever the decision is, I hope that the families and those that have been connected to this case somehow, I hope that they are prepared for whatever the judgment is. So I think that's the only way to really focus on this right now. Otherwise, it has been real. It has been fun. It has been real fun. So I would hope to see y'all tomorrow. I can't believe we're here, but it's the beginning of much more to come. So I appreciate your support so much. And thank you for helping me get out this case and get some more eyes on it. And as a result, hopefully make my community a safer place. Have a lovely Tuesday, Taco Tuesday. I'm having meatloaf, but I'll see you guys tomorrow morning. Let's say 9:30. Because I like being able to speed up. I don't know about you guys. I've really found that to be helpful. So let's do 9:30. And if I change to 10 o'clock, I'll let you guys know in the chat tonight. I have already uploaded the icon. I just have to create the event in my dashboard so you guys will see it if you have notifications turned on for my channel, which I suggest you do. Here, this is how you do it. Oh, show this tab. Okay, so you go here, you're watching my video, right? And you join. Okay, maybe not. I totally know what I'm doing. You'll see. How do I do this? How do I always do this? There should be something right here next to my name that has a bell. And you click the bell and you'll see like turn on notifications. So I hope this helps. And that'll allow it so that you get notified no matter when I go live, in case that time changes or, you know, the internet stops working like it did today. Okay, this is enough. I'm going to keep rambling. Thanks, guys. Thank you so much for everything. Thank you, maybe, for modding, and all my viewers, those far and local. Appreciate you guys. Coco Shamiao, say goodbye. Meow. Okay. Have a good night. I'll see you guys tomorrow morning regardless. Keep a lookout for the notification about tomorrow's stream and it'll say the time. Bye.